Are we live? Yes, we're ready when you are.
What's the case number for you?
9387. 87.
Good morning, everyone. Today is August 21st, 2024. The time is 9:07 a.m., and we are here at the Town of Pembroke Park Code Enforcement Special Magistrate hearings. I thank you in advance as I will be reading an opening statement as to how these proceedings will be governed, so I thank you for your indulgence. Ladies and gentlemen, welcome and thank you for being here today. Please turn off any cellular telephones to avoid interrupting these proceedings. There are no weapons of any kind permitted in these chambers or anywhere within these facilities. In all issues that may come before the Special Master, we ask that everyone show mutual respect for one another by listening quietly to each person speaking, and that everyone refrain from any clapping, heckling, or verbal outbursts in favor or in opposition to a speaker. These are hearings conducted by a special magistrate. That is me. My name is Andre McKinney. I'll be governing the proceedings today. The purpose of which is to give any alleged violators the opportunity to contest the decision of the code enforcement officer which resulted in the issuance of a civil violation notice. These hearings are conducted in a quasi-judicial manner, and I am the special master assigned to hear today's cases. My responsibility is to act much like a judge in court, and that is to hear cases presented by the code enforcement officers and to hear contradictory arguments presented by the alleged violators. These hearings are open to the public. It is required that all persons who testify as to the facts of the case be placed under oath, including the code enforcement officer. These hearings will not be conducted in accordance with formal rules relating to evidence and witness. Any relevant evidence will be admitted if I find it to be competent and reliable, regardless of the existence of any common law or statutory rule to the contrary. All documentary evidence must be submitted for placement in the hearing file. No documentary evidence will be considered unless the alleged violator or code enforcement officer submits a copy for the hearing file. Each party shall have the right to call and examine witnesses, to introduce exhibits, to cross-examine opposing witnesses on any matter relevant to the issues, even though that matter was not covered in the direct examination, to impeach any witness regardless of the first party which called him or her to testify, and to rebut the evidence against him or her. It is my responsibility to make findings of fact based on the evidence of record. The fact-finding determinations of a special master are limited to whether the alleged violation occurred, and if so, whether the person named in the civil violation notice can be held responsible for that violation. I may also modify the decision of the code enforcement officer as to the time for correction contained in the civil violation notice, even though said time is rebuttably presumed to have been reasonable. I have authority to assess and order the payment of civil penalties, to issue orders having the force of law to command whatever steps are necessary to bring a violation into compliance, and to assess administrative costs. In order to make a finding upholding the code enforcement officer's decision, I must find that there is substantial, competent evidence that the named violator was responsible for a violation of the relevant section of the code as charged, If I affirm the decision of the code inspector, my order will specify the amount of the civil penalty, the administrative cost of hearing of not less than $100 if assessed, and the date by which the violation must be corrected to prevent resumption of continuing violation penalties, if any. An aggrieved party, including the town, may appeal a final order of the special master to the Circuit Court of Appeals. Such appeal shall not be a hearing de novo, but shall be limited to appellate review of the record created before the special master. An appeal shall be filed within 30 calendar days of the issuance of the order sought to be overturned. If you are found guilty of a civil violation as charged, you will be assessed an administrative fee of $100. The city representative will present their case first, and the alleged violator will present their case thereafter. I will consider the evidence and render a decision after all arguments are heard. All those who will be testifying in today's hearing, please stand up if you're able to do so and raise your right hand. Do you swear and affirm? Okay, thank you. Do you swear and affirm that the testimony that you will provide in today's proceedings will be the truth and nothing but the truth? Say I do.
I do.
Thank you. You may be seated. Officer Ramirez, we can commence with the agenda.
All right, roll call. Chief Code Compliance Officer Jocelyn Ramirez, present.
Code Officer Gene Gusson, present.
Brian Sherman, Assistant Town Attorney.
Andre McKinney, Special Magistrate, present.
Nasli Cardona, Code Clerk. Mary Carey, Building Clerk.
Next, we have the adoption of minutes for July 17, 2024.
Are there any modifications or additions, or are you moving it as presented?
Moving as presented.
Okay. So moved.
Okay. Next, we have the adoption of agenda deferrals, additions, and modifications. We do have some modifications. We have case 5378 was added to the agenda for abatement of fine.
That was 5378?
Then we have case 7447 added to the agenda for abatement of fine. We have case 8609. It has been removed from the agenda. The respondent complied before the hearing date. And case 8756 added to the agenda for an abatement of fine.
Okay, the agenda is so moved and entered with the additions and modifications as noted.
Okay, and so we can begin with we're gonna begin with the attorneys first, and then in the order of the people arrived. Beginning first with case 5534, which is on the section 9.5. Case 445, which is on section 9.3. And case 5466, which is on section 9.4. Chief Code Compliance Officer Jocelyn Ramirez for the town of Pembroke Park. Case 5534, property owner Pembroke Crown 3 LLC. Site address 2533 through 2575 South Park Road. A notice of hearing to abate fine was sent by certified mail, July 24, 24. Posted to the property August 7, 2024. Posted to Town Hall, August 9, 2024. It is the town's motion to abate the fine of $39,100 and reduce it by 85%. That total amount is $5,950. Then we have case 5445. Property owner Pembroke Crown 3 LLC, site address 2533 South Park Road, Pembroke Park, Florida. A notice of hearing to abate fine was sent by certified mail, July 24, 24. Posted to the property August 7, 24. Posted to Town Hall August 9, 24. It is the town's motion to abate the fine of 1 second, technical difficulties.
I'm just putting them in the, okay. I'm gonna put them in the order of the agenda.
I can continue? Not yet?
One audio, give me 1 minute, it's gotta refresh, it'll be up.
Okay, just let me know.
Thank you for your patience, everyone. Just technical difficulties.
Good? Okay. So for case 5445, are you ready? Okay. It is the town's motion to abate the fine of $75,350 and reduce it by 85%. That total amount is $11,388. Now for case 5466, property owner. Okay. It is the town's motion to abate the fine of $75,350, reduce it by 85%. That total amount is $11,388. We're good? Okay.
It's,
Okay. It's better.
No.
are we good to proceed? All right.
All right. Case 5466, property owner Pembroke Crown 3 LLC, site address 2575 South Park Road, Pembroke Park, Florida. A notice of hearing to abate fine was sent by certified mail July 24, 24, posted to property August 7, 24, posted to Town Hall August 9, 24. It is the town's motion to abate the fine of $134,850 by 85%. That total amount is $20,313. Okay?
Does that include the administrative?
Yes, it does.
Is anyone here on case number 5445, 5466? Oh, perfect. I put them in the order of the agenda just so that sequentially, okay. So in order of the agenda, under the abatement section, we will commence with case number 5445. If you could please state your name for the record and who you represent. Thank you, Counselor.
Thank you. Good morning, Special Magistrate. My name is Jeremy Shear on behalf of the owner of the property, Mr. Tony Roz, standing right next to me. And as a preamble, I would just like to state that my client purchased older properties in the town. He has spent a lot of money and time in trying to bring them up to, the current building code and the current code of the town. The town also lost all the permits for these properties, so many of them could have been considered legal nonconforming, and now we just can't establish that. So I just want you to keep that, in mind when we're talking about these older properties. Case 5445, 2533 South Park Road. This was for a BTR. So please note that immediately after the lease was signed, my client applied for the BTR and an inspection ensued. The inspection found multiple issues with the existing building, which ultimately my client had to remove a 2,500 square foot mezzanine level, which led to the loss of significant revenue. He consulted with a structural engineer, with an architect. Ultimately, he decided to play it conservatively to be safe. But I just want you to keep that in mind, that he spent significant funds on and lost revenue, annual revenue, which he did not believe he was going to have to do. Additionally, the issues which held up the BTR that were found in the inspection were cited in a separate case, case 5465, which has already been resolved. So these cases really should have been combined, because obtaining the BTR was totally dependent upon the work done in 5465. I also want to state that for many years, this mezzanine level was found to be safe by the town building staff, was used for the annual Christmas party, which town staff and elected officials attended every year. And really the fact that the town lost all the permits has really shifted the ground from, establishing whether or not, there are legal nonconforming sites. And this is a major disinvestment to investment in your town. My client is a good actor, and, like I said, I think you want to make sure that you're incentivizing the right kind of people and corporate citizens to be here. So based on that, we're asking for a reduction down to 2% for a total of $1,500.
What's the town's position with regards to the counter of a 2% reduction, which would bring it down to $1,500?
Madam Magistrate, we just leave it at the standard to keep it fair for everyone. So the reduction, it would be 85%.
As I mentioned, Special Magistrate, the only reason that my client wasn't able to obtain the BTR was because there was work that was required to be done. That work was already included in case number 5465. So you're essentially penalizing him twice for a case that's already been cured.
And specifically, what was the work that you describe as it relates to 5466, just so?
To 5465, you mean?
Did you not say 5466?
No, so 5445, which is the case before us,
Right.
was for lack of a BTR. The BTR was held up because the inspection found that work had to be done and permits had to be applied for. That work, those permits were included in case 5465, which has already been closed. And the work that,
That case isn't before me.
Correct, that's what I was going to say.
correct, but that case has already been closed.
Okay.
And my client has already paid a mitigated fine on that case. So we're just dealing with the BTR, but the whole reason, that BTR really should have been included in case 5465, which has already been closed.
Right, I understand. And so that case, while it's not before us,
Right.
the essence of that violation is what predicated your client not being able to resolve the case before us. So based on your request for a reduction further than the 85%, what is that factual basis in terms of that other case that you're asking me to consider? I don't have that case before me, but you're
Right.
bringing it up as to the particular violations. So I'm asking you, what are you putting forward on behalf of your client that justifies a reduction further than 85%, right?
Right, so good question. So the nature of the work that had to be done in case 5465 included interior renovations, the mezzanine level, which I mentioned, which my client spent many months consulting with the architect and the structural engineer to see if that could be kept, because, you know, that was usable square footage, habitable space. Ultimately, like I said, after many months, he decided to remove that mezzanine, electrical work, racks, and exposed wire on the exterior of the building. So really the essence of what I'm asking is the fact that the BTR was completely dependent upon work included in a separate case that has already been closed. I don't know why they were separated. That BTR should have just been included in case 5465, and then we wouldn't be here today on 5445. So that's really the reason why we're asking for a significant reduction. He already paid a mitigated fine, a hefty mitigated fine on 5465.
Okay, I have a question. What was the violation date for 5465?
We don't have this case on file for
No.
now. I mean, we're here to hear case 5466 for a reduction of
if I-
fine. That case was open because of all the work that was done without permits from the business.
No,
the
my,
tenant.
my question is more in terms of the date, not the essence.
Right, but we don't have that case filed for today's hearing.
No, I'm asking Attorney
you're-
Shear.
Okay, no problem.
I don't have the exact date, but I do. Let's see here. December 2020, and then the mitigated order was August of last year, August 16th, 2023.
Okay. You have anything else to add before I provide oral pronouncement?
On that case, just what I've stated, that it was completely dependent upon the work that was included in case 5465, so really they should have been merged together. Otherwise there wouldn't even be a new case, 5445. So I think the nature, the extraordinary circumstances in this case do, provide you some, substance to reduce it more significantly than the town is recommending.
Officer Ramirez?
Madam Magistrate, there are two separate violations. There's work without permits. You have to obtain your permits, and then you have to obtain your business tax receipt. Both are separate.
Right, but one is dependent upon the other. You can't obtain your BTR until you
But
pass all your permits and the
initially,
work is done.
When a tenant comes in, they have to follow the protocol so they don't come up with these issues.
Anything else from either side? Attorney Shear, anything else on behalf of your client?
No, not for this case.
Okay. The town has offered a reduction of 85%, which includes the administrative costs. That brings it to $11,388. 1 second. The town has also rejected your counteroffer of $1,500. My oral pronouncement is such, based on the testimony and evidence presented, there is substantial and competent evidence to approve your request for abatement. The property is in compliance. The fines have been offered to be mitigated by the town of $11,388. You are asking for an additional reduction. I will offer a reduction of, a further reduction by $2,500, which brings it down to $8,888. That does include the administrative cost. You must pay the mitigated amount within 30 days, or the original fine amount will resume.
Special Magistrate, I'd ask you to reconsider. Like I said, the BTR is completely dependent upon work that was included in another case that my client already paid mitigated fines on. We would ask for a more significant reduction. I think the circumstances dictate it.
The original fine on this case, it's almost $80,000. Your reduction is greater than 85% with the further reduction that I've provided. And the standard as...
Can we go to 5,000?
I'm not going to reduce it to 5,000. 5,000 would, 85% is a lot. I've taken off 2,500. If you need, or your client needs time to pay, he's free to ask the amount of time.
Well, I think I've stated the case. 2,500 is, we appreciate that, but we don't feel that that is significant enough based on the circumstances. If we could get another reduction, bring it down to, $6,000, that would be appreciated. Once again, this is, work. The BTR should have been included in case 5465.
As I'm sure you're aware, Attorney Scheer, violations, they're cited when they're cited. Applying for a BTR is a prerequisite before any business commences. I'm not going to get into the essence because we're here to discuss the mitigation. Again, the town has made an initial offer of 85%, which is $11,388. I have reduced it by $2,500, which brings it to $8,888.
Okay.
And if Mr. Ross, if your client, if he needs time to pay, he can speak with the town with regards to payment arrangements.
It's about $6,500. Yeah. Okay, just for the record, my client paid $6,500 already on case 5465. Which case would you like to hear next, Special Magistrate?
Well, I'm going in order of the mitigation section, abatement section of the agenda. And with regards to the amount paid in the other case, that's not relevant to this case. And my question, just so we're clear as to when that case was cited, was the only question. But your client has come into compliance, and that is certainly commended. And I'm sure the town appreciates that. And we're here at mitigation. At the conclusion of all three cases, your client will receive an order. So we can call the next case. Officer Ramirez?
Madam Magistrate, what is the order ruling for case 5445 and case 5534? We had three cases for this
Right, and
particular respondent.
Right, and he's going to be heard on each.
I already read all three of them. in the
Oh, okay.
record.
So
Do you need me to state the amounts again?
I can pull, yes, if you could. And Mr. Shear, are you ready for the next case?
Yes, just tell me which one you'd like to hear.
On the
So-
agenda, it's 5466.
Okay,
I'm going in order of the agenda,
right.
which is 9.4. I don't know if you have the agenda before you.
No, but now we know the order. There's 3 cases, so this is 2, and we know what number 3 is. So case 5466, once again, 2533 South Park Road. There's a $134,850 fine. This violation cites a lack of BTR, but per my client, there was never a tenant. We never applied for a BTR, and it was simply used as overflow storage with no business and no tenant until December of 2023, when a new company moved into the bay. Additionally, the case cites interior renovation done without permits. We did a public records request to the town. The town has not provided any proof of any work done without permits because there were no interior renovations done without permits. So please keep that in mind. And then also, this violation cites the Stratton sign being removed. Once again, the Stratton sign is included in a separate case, 5534, which you're going to hear next. That sign was literally just stickers on the wall. So, once again, if the town has any, photographic evidence, they can please provide it. But per my client, per the response, there's no photographic evidence of any interior renovations being done because there was no interior renovations done, and there wasn't.
Attorney Shear, we're here for mitigation, so I'm presuming that Mr. Ross submitted an application for mitigation. The amount that the town has offered is $20,313. That does include the $100 administrative cost. And for the record, Officer Ramirez, is this an 85% reduction off of the $134,850?
Yes.
Okay.
Right, okay, so thanks for the clarification. So we're asking for a reduction down to 5%, or a total of $6,700.
What's the town's position to the counteroffer?
85%.
Anything else, Attorney Shear? They've rejected your offer.
I heard that. Once again, the case cites interior renovation done without permits, but there's no evidence to that fact. So, that's why we're asking for a reduction down to 5%. Once again, there was no tenant, so there was no need for BTR. It was just used as overflow storage.
Anything else?
Nope.
I'll go ahead and render my oral pronouncement. Based on the testimony and evidence presented, there is substantial and competent evidence to approve the request for abatement. The property is in compliance. The fines are mitigated down to $20,313. This includes the administrative fee. The respondent must pay said amount within 30 days, or the original fine amount will resume.
Okay, so you're not mitigating it any further than what the code director is offering, just to clarify?
The town, yes, I am not.
Okay. Case 5534, 2533 South Park Road. These are all repetitive violations. This should be reduced to 0 because the 3 violations that are cited here include the Stratton sign being demolished without a permit. As I mentioned, that was just heard in the previous case, case 5466. So town staff is including multiple issues in different cases. So I'm stating that for the record because I want that entered into the record, and I want you to consider that seriously, Special Magistrate, that these are repetitive issues being included in multiple cases. Okay, so the Stratton sign, as I mentioned, included in case 5534 before you, also included in case 5466, which you just heard. It also cites exterior concrete renovations being done without a permit. There were no concrete renovations that were done. It was just a permit to paint, which was approved by Mike Miller, the former planning director from the town, and Miguel Nunez, the former building director of the town. They approved the color. And finally, it cites the demolition of an overhang canopy without a permit. This permit had already been received in case 5465. So once again, duplicative issues included in multiple cases. That permit was already approved. So based on the above, we're asking, because these are all duplicative violations that were already included in separate cases, we're asking for this one to be reduced to $0 because really there is no substance for this case. All of the issues were included in other cases. I mean, otherwise, you know, essentially the town is saying we can cite property owners for the same issue in multiple cases. That does not seem like a legal or kosher thing to do. Okay, so please keep that in mind. We're asking for this case to be dismissed.
This is a mitigation request, Attorney Shear.
We're asking to mitigate it to 0.
What's the town's position?
Madam Magistrate, so this violation was, they did stucco work on the building, they removed a canopy, and they actually obtained the permits to correct this. So if there was no violation, how is it complied with the permit? They went ahead and obtained plans and completed this permit. So again, the position is 85% reduction.
Feel free to.
Assistant Town Attorney, do you have any weigh-in with regards to the duplicativeness? And I do want to note for the record that these are repeat violations. Assistant Town Attorney?
Madam Magistrate, if I may, I haven't had a chance to review the particular issues as far as the duplicativeness, as far as the factual nature of it. What I can say as far as the general law is concerned is that you are correct that we're here for a mitigation, that a finding of fact was already found, that order is already been determined, and the time to appeal that order has expired. As to multiple violations in multiple cases, as long as there is one that is different, then at that point that's would be, because all these cases are not individually fined, they have individual, it's one fine for all the different violations. So without further review, factually, I wouldn't be able to opine as to that, but I'm also not going to stand as the appellate judge of the magistrate that found the violations in those cases. So that's what I can add and for you in these matters.
Attorney Shear, the town is rejecting a 0 mitigated amount. Do you have another counter?
Sure. Our counter would be 5% based on the total of $39,000.
The town's already, this is 85%, so the balance is what, 39,100? This is case number 5534, and the town is offering 5,950.
Right, so we would request a 5% based on
5% of the total amount?
5% of the 39,000, as I mentioned. They're all duplicative. They've been included in other cases, which would be 1950, I believe.
She's telling you you can mitigate, you didn't come to talk about the case, so what is there else to say? And what? Pembroke Crown? 35 years. We've been dealing with this problem for the last 5 years. We can get out of our own way.
Anything else, Attorney Shear or Officer Ramirez?
No.
My client would like to add
Yes.
something as well.
Hi, Magistrate. 35 years in this town. My companies are called Pembroke Crown. I used to be proud of being here. You know? And I try to take the point of renewing, making better, making the street look better, doing whatever other people of Rimby Beatty didn't do for all the 30 years. And I find myself whereby I'm here. $20,000, $100,000, $200,000 fines, repetitive. This is not normal. For me, it's not normal. We had peaceful and joyful 25 years of work. For the last 7 years, it's like raining hell. And we're still not done. It just continues. You know, Jocelyn, with all due respect, is sitting on our properties from left to right, from right to left. And it's just, you know, my staff is trying to comply on a daily basis, but we get caught in situations that all of a sudden it's a year later and we still can't finish it, okay? And this is what happened with 2533, 2575, and a few other properties. 2727, it's not in front of you, yes, but it took 7 years to close the case, you know? So to be fined and to be at a point where we got to pay $20,000, you know, I'd rather make donations to the town. It doesn't feel right. It doesn't feel right. It's wrong, and I would like you to reconsider both these amounts. We're having a hardship, you know. We can't do certain things, and the fire marshal has certain requests. We can't get out of our own way, and I'm sure a lot of people will tell you the same thing. I don't know how to solve it. I brought architects, I brought surveyors, I brought different professionals to figure out certain things, like the mezzanine that he spoke about. We had to close it off. The city, the town of Pembroke Park used to use this facility every year. So how come all of a sudden it became a problem? I don't know. It doesn't matter. I fixed it. I lost 2,500 square feet of space that I can rent. We closed it off. We spent hundreds of thousands of dollars. Okay, so we're trying to comply. But here, to get violations for $10,000 and $20,000 and look at $100,000 violations, you got to reconsider, please. You know, we want to do more. We would like to help the town, you know, beautify it and all. You know, when you come and you ask for stripes, done. When you come and you ask for this, done. We'll do it. We'll take care of it. But when it's a repetitive scenario where we can't finish it, we can't get out of the situation. How do we finish it, Jocelyn? How do we do it? It's impossible. I told you, we brought all the professionals we could. We spent a lot of money on architects and, you know, contractors. But we can't find a way. And I'll continue to work with the town. I'll continue to do what it takes. But you got to help us and not penalize us for trying. You know, I haven't bought a piece of property in Pembroke Park for over 2 years because of this. And we can't vote. We can't do anything. We don't have a voice even. We have hundreds of thousands of dollars or millions of dollars worth of investments, and we can't say a word. We can't talk about anything. So help us, help you. I want to see the town flourish, but we're punished. And this is punishment. Start every day something else. And again, because of the fact that you can't close this stays open at $250, $500 a day. How does that make sense for us? You want to damage us? You want to hurt us? So we go home feeling like, oh my God, how do I finish this? Please reconsider. Give us a break. Let us work with you guys. I always worked with the town. I'm here for 35 years.
Mr. Ross, we're going to hear this case. I am going to grant you a reconsideration on the prior case.
Please.
But let's finish up this case, and then you can add.
Can I just say something about that sign?
Well, let's finish up this case. You've
Okay.
asked for a reconsideration on the prior case. You'd like to add more information, so I'm going to grant you that. But let's finish up on case 5534. Mr. Attorney Shear, you requested a mitigation of 3%, which I think is, what's the figure? Because I swapped cases.
3% of 39,000, I'll tell you in 1 second. $1,170. Is that right?
You have anything else to add on 5534?
No.
Based on the testimony and evidence presented, there is substantial and competent evidence to approve the request for mitigation. The fines have been mitigated by the town in the amount of $5,950. The respondent is seeking a 3% reduction, which would be $1,170. I will reduce the mitigated amount down to $2,200.
Thank you.
The respondent must pay that amount within 30 days, or the original fine amount will resume. The respondent on case number 5466 has requested a reconsideration. I will grant the reconsideration so that the respondent, Mr. Ross, can be heard on same. Mr. Ross, you have the floor.
This is no regards to the sign.
5466, right, Special Magistrate?
Correct.
Right.
Okay.
Let me just double check that.
One with a cited lack of
Yes.
PTR, but you never had a tenant in there. And then same thing with the interior.
And so
elevation.
just to
Just using it as
recap,
overflow storage.
the testimony we've already heard on this mitigation, the accrued fine amount were $134,850. The mitigation amount by the town was 85%, which was an amount of $20,313.
Okay. And this is the one that we didn't have renovations. We didn't have anything done inside. The sign outside or the canopy. I didn't start doing this work until I came into the town. And I sat in this office and I spoke to Michael Miller and Mr. Nunez. And it took us almost a month to get to the point where I can get the colors. And finally it was done. And the stickers on the wall, if you have a picture, you look at it, it was a sticker on the wall that says Sprint. It's no mechanical, there's no wires, there's no bolts.
But we're talking about the reason why you should be granted a further reduction.
Well, it's a terrible hardship.
Okay.
I mean, we didn't collect rent for that place for a long
You
time.
never had a tenant.
We didn't have a tenant so it's a real hardship. I mean, it's a situation where it's not like we're not trying to comply. You know, the thing is with the violations, until you get to the point where it's closed, it's a $50 or $200 or $500 a day. I mean, that's horrible. We don't know how to get out of our own way. We're trying. If we didn't comply and you didn't see us doing stuff, then I can understand, but we're trying. But as long as we're trying, it's, to mitigate these fines and to make them, realistic that we could deal with it. If we didn't collect the money on 2533, we're losing somewhere around $40,000 a year.
And you did indicate, or Attorney Shear, that you now have a tenant, correct?
Yes, ma'am.
Okay.
Finally, we did a whole layout with structural planning, lighting, everything. We did the work. We got it approved. The tenant moved in. Everything is good. Now
Okay.
we're starting to collect rent.
Okay.
For 2 years, we didn't collect rent.
Right, but this notice of violation was from December 2020. My client only got a tenant in there December 2023.
Okay. And Mr. Ross, again, the town has reduced this by 85%, which is $20,313. What is your counter,
What did we
Mr.
say?
Ross?
$5,000. $5,000?
I mean, we had asked for 5%, the town has 15%, can we settle at 10%, which would be approximately 13,000? Okay, I mean, let's, or somewhere, maybe 8%. Let's do $10,000. That's still a significant sum of money, considering the fact that my client never had a tenant in there and he was cited for lack of BTR.
$13,000. I'll mitigate it to $13,000.
Okay. I'm gonna need time.
You can speak to the town with regards to that.
There's no way we can write a check for these. We're not collecting the money.
And you can speak to the town with regards to the payment arrangements. Anything else before I enter or pronouncement as to the rehearing?
Madam Administrator, if I may?
Yes.
If they're saying more time as far as working out the payments with the town, again, the town is going to just take one payment, but as far as your initial order was 30 days in order to pay the amount in full. So if you were going to adjust that, now would be the time.
How much time do you need to pay this?
Well, what did we do last time? We broke it up into 4 payments.
120 days.
Yeah. We'll break it up into 104 payments.
And this is for all 3 cases?
Yeah.
Okay.
So, Madam Magistrate,
Well, we're here on, this pertains to the rehearing. Mr. Ross or Attorney Shear haven't indicated whether with regards to the other 2 cases, if they need time to pay.
Yes, ma'am.
Okay. Does the town have an objection with regards to all 3 cases being paid within the span of 120 days?
No.
so Madam Magistrate, with that, the town would agree to 120 days to pay all cases.
I'm going to give the oral pronouncement, and then I'll give instructions that you need to hear, Mr. Ross. Case number 5466, at the request of the respondent on a motion for a reconsideration or rehearing, same has been granted. This case is on for abatement of fines based on the testimony and evidence on rehearing presented through Mr. Ross, the respondent, owner of the property. Again, there is substantial and competent evidence to approve a request for abatement as the property is in compliance. The fines have been mitigated down to, by the town, to $20,313 upon further request and testimony of hardship by the respondent. That amount has been further reduced to $13,000, which includes the $100 administrative cost. This amount must be paid within 120 days or the original amount will resume. With regards to case number 5445 and 5534, the respondent has 120 days to pay same or the original amounts. For those cases will resume. Anything else you'd like to add, Mr. Ross, before we conclude?
Yes. I would like to work closer with code enforcement so we don't get to these levels. A little conversation in between before we get written up.
Yes, I call Iris all the time.
Okay, we just got to get to a better working scenario so we can not get to this point. You know,
Absolutely.
it's not like we're not going to do the work. We're going to do whatever it requires. Just a little more communication. That's all I ask for.
Yes, teamwork makes the dream work.
Thank you, Special Magistrate. And just to clarify, will the final rendered orders be emailed to my office, to my client?
He's going to,
I will give them a copy.
if he has time to wait, he's going to get them now.
Okay.
Mr. Shear, you can reach out to us or make sure that your information is with the town. If you don't get it, let me know. I'll be happy to provide a copy.
Thank you, Mr. Town Attorney.
Thank you.
Thank you.
Madam Magistrate, if I may.
Yes.
We have someone already approached the podium. Ms. Dawson, I'm assuming?
Yes,
And you are an attorney?
yes, I am.
Excellent. And I believe you have a court reporter here? Is that
Yes,
on this
I do.
case? All right, so
Yes.
Madam Court Reporter is here on this case. Also, for the record, I want to say Mr. Pizzi, correct? Mr. Pizzi did come a little bit late. He is an attorney, so he was not able to sign in, but we'll take him next. You know, I don't think,
Yes, please, thank you.
that's what we do. I saw that you came in, so we're going with the order. I don't believe there's any other attorney signed in, so that's what we will do.
And thank you. We got our attorney coming in, he should be here within 5 minutes.
Well, sir, right now I recognize Mr. Pizzi. If you have an attorney coming, just have him approach me and I'll have a conversation. Happy to do that. But again, we're just going in the normal order, so he should have plenty of time to be here. And then if your case gets called and you like to wait, just say so, please, sir. And we're happy to wait to the end of the docket or later in the docket. Madam Magistrate, would you like me to call the case if you're ready?
Let me just finish this so that I
Yes.
can have
Yes, ma'am.
divided attention.
mentira, mentira.
Thank you. Okay. Is the next case number 9150?
Yes, on section 8.6 of the agenda. Chief Code Compliance Officer Jocelyn Ramirez for the Town of Pembroke Park, case 9150, property owner 31924 West Hallandale LLC, care of Management Office. Site address 3192 through 3194 West Hallandale Beach Boulevard, Unit J. A notice of hearing to confirm fine was sent by certified mail July 19, 2024, posted to the property August 7, 2024, and posted to Town Hall August 9, 2024. It is the town's motion to confirm the fine of $16,100. And the property is still not in compliance as of July 19, 2024.
Good morning. If you could please state your name for the record.
Yes.
And who you represent.
Yes, my name is Angela Dawson, and I represent the tenant, which is Fritas Hospitality Group, also known as Kelsey's Lounge.
Okay, so your client is the owner of Kelly's Lounge.
My client is the tenant. The owner of the property is the 3192 4 West Hallandale LLC Management Office. I don't believe they're in attendance here, and I'm not sure if they've ever attended any of these hearings.
Okay, are you authorized to speak on their behalf?
I am speaking on behalf of my tenant, Kelsey's Lounge. Let me just give you a little background. I was just recently retained, and I have excusable neglect. I recently was, I'm the caregiver for my mom, so we were in the hospital for the last 10 days at Holy Cross. So when she goes in the hospital, I move in that room with her, so we just got discharged last night. I did reach out to Officer Ramirez yesterday, entered my notice of appearance to let her know that I'm representing the tenant. And I asked her for a continuance in this matter. I haven't had an opportunity to review the file, any of that. So I hired the court reporter to, get this on the record. Also, there's a due process issue here where the tenant, Fritas Hospitality Group, has not received these notices of hearing. Apparently, they're going to the owner, the management company, and but this particular notice of hearing was posted to the door on August 7th, and that was Mr. Fritas's notice of this hearing. So I don't have any idea of the dollar amount of the fine until just now when it was mentioned. Also, I'm not sure how we even got here because Mr. Fritas has hired an architect and a GC and has applied to come into compliance with, I believe the issue is soundproofing, getting the unit soundproof. So my tenant has spent actually over $1 million so far renovating this building that he's renting. So the soundproofing issue is new, and he is trying to do his best to come into compliance. He has,
Attorney Dawson?
Yes.
Just so I'm clear, I understand that you've just been retained. You sent your notice of appearance. So first things first, are you asking for a continuance?
Yes, I am. I'm
Okay.
asking for a continuance.
Does the town have an objection to a continuance?
Yes.
Okay, and what's the basis of the objection?
The tenant did request an extension to get it corrected. That extension was approved, but there was nothing moving forward with the permit. The permit became void, so none of the work was done. We are still receiving complaints from residents that there's still ongoing noises. So that's the reason for the objection.
In response to that, Mr. Freitas has transmittal with the activity in terms of trying to get the renovations accomplished. Also, in that strip mall, there are several businesses there's a gym on the west side, the end of the building, where they have parties in the parking lot. So
Well,
I know we're not going to get into.
Well, I'm going
that.
in order, just based on what you laid out. So the town has an objection to the continuance, and they've stated the basis for same. And so it may appear, no attribution to the attorney recently retained, that this may be a dilatory tactic, and that would serve the basis for the objection for an extension. Moving on to your second position that you raised with regards to, is it your position that notice for this hearing, that due process was not served for this hearing?
Well, it's my position regarding this hearing and also the previous hearings, how all of this came about. As I stated, Mr. Freitas is a tenant, and apparently all of the notices have been going to the owner, who has failed to appear to any of these hearings. So I want to protect my client's rights, wherein there may be an issue with the lease between the owner and the tenant, where if there's any fines or violations, it may be, automatically imposed upon the tenant. I'm not sure. So like I said, I haven't had an opportunity to review any of that, so I want to preserve my client's rights.
Okay, I understand. And just to clarify, Ms. Dawson, and you actually touched upon a few of the things. The owner of the property is the one that's cited for code enforcement violations. And in this instance, this is a commercial use. The owner of the property is renting to a tenant. That's a private and separate legal matter outside of these proceedings. So the basis for a lack of due process as it relates to the owner of the property who was cited pursuant to 162, I don't find a basis for that. Whether or not the owner of the property elects to show up at a hearing, that is his or her prerogative, as long as the city adheres to providing notice. Someone who chooses not to show up to have an opportunity to be heard, that's on them.
Understood.
Now, with regards to your tenant and with regards to what his lease may call for with the owner, that's outside of this process, which leads me back to an original question that I stated or asked. And either side is free to answer the question if you know, and that is, are you here on behalf of?
No.
Okay. So you're not representing the owner of the property in these proceedings as an attorney or an agent. So without some sort of authority of the owner to speak on this case, which is on for confirming the fine, you're not the person to be able to speak on behalf of the owner. It's not your property. It's not.
Correct. I understand that. Mm-hmm. The reason that I'm here is to, preserve my client's rights. If they're...
And perhaps you should reach out to the owner and or the owner's attorney.
Yes, I will. But I want it on the record that I'm preserving my client's rights. I have not had an opportunity to review the file. There may be a clause in there regarding code violations in the lease, who's responsible, I don't know.
Attorney Dawson, code enforcement proceedings and cases, if you were here when I gave the opening statement, they are open to the public. You can make a public records request for a code enforcement file. So that's well within the statutory means
Yes.
that any member of the public may exercise. So
to date, what is the fine that is supposed to be confirmed today, the dollar amount?
$16,100.
Okay, and that covers from what period?
That period is from beginning June 18, 2024 till August 21st, 2024.
And Ms. McKinney, if I may,
Yes, yes, yes.
and Ms. Ramirez, please correct me if my memory is incorrect, but I believe that the gentleman here, the respondent, was actually here. I think the hearing was, what, December? We had an extensive hearing. A number of people spoke on the matter, as well as the respondent spoke on the matter, and then the order was then rendered, which is before you here today. And then there was an extension that was granted by the town, and then we're here today. So I just wanted to give you, I don't know if you were, which magistrate heard the actual hearing, but as far as more of the historical part of that, I wanted to let you know.
The respondent looks vaguely familiar for prior hearings, not in any other capacity, so. But is there a way for you to pull that information up?
Yes.
Well, the issue is, well, I know the hearing today is confirmation of the
Ms. Dawson, if we could allow Officer Ramirez, because I do want the record.
The ruling was done on January 17th, 2024, and the special magistrate was Harry Hippler. Is that what you're asking?
No, does the record reflect whether this gentleman?
Was here? Mm-hmm. Yes, he was.
Okay. And Attorney Dawson, I do want to be clear, because this case, you're not here on this case because you are not here representing the owner of this case.
Understood.
And so that there are no misgivings with anything you're saying in terms of affecting that owner or any of what you're stating being attributed to a representation for the owner of the actual property. Usually this isn't the setting or the form. As I said, you can request the code file via public records. The record reflects that your client was at a prior hearing. And so I'm sure in speaking to your client, he can edify you accordingly.
Yes, I believe the issue is that there have been no steps taken to rectify the problem. And we have proof, evidence, transmittals regarding the activity to get the renovations accomplished. So the tenant, my client, would be asking for an extension to get the situation remedied. He would be seeking
20 days?
6 months.
Madam
Because
Magistrate,
there's,
I'm sorry.
Attorney, yes, Assistant Town Attorney.
I'll let Ms. Dawson finish. My
Yes.
apologies.
And we need to get, we don't never get no notification. We requested that. I requested as a tenant, I requested that the first time we was here. If we could get some kind of correspondence directed to us so it wouldn't be a mishap. The same thing that happened in that here, the same thing that's happening right now happened the first time. We wasn't notified until something was put on our door. So as a business owner, we go ahead and I go above and Call of Duty to come in here and kind of fix stuff and get everything going. It was a permit that was null and voided, but we didn't know it was null and voided. I had to write another check. Here's the receipt for that check that I wrote to the city to get that reinstated. They issued me another application I had to do. But when they took my check at that time for the permit, they didn't tell me that we had to redo another application. So my GC was unaware of that. So we lost a month just sitting there waiting for the response, which never came. And then as soon as that came through and I found that out, then there you go. There's 2 more submittals of stuff that we've been working on to get this thing rectified. Soundproofing, like I stated before, is very difficult because the city doesn't have no measures of how to monitor it or say, hey, it's done. So it's steps. So now we have to do it in steps. It's just, you can't just say, hey, it's soundproofed and that's it. And that was also brought up at the first time because there was no decibel readings that the city had enacted that say we violated. It was just personally complaints.
We're here to confirm the fine. That's the subject of this hearing for the property owner.
We didn't know about
You're not the
fine.
property owner for the
Oh,
record.
yeah, I'm not a property.
You're not the property owner. Assistant Town Attorney.
Ms. McKinney, at that time, the respondent was allowed to present. It was an extensive hearing as far as what was agreed to on the record was in the order. Then, so really the issue simply before you would be to, I guess, obviously the continuance for the attorney, or whether to grant the extension. The town's position is, again, objecting to it in the fact that we already had an extension. And as far as notice, you are correct that notice goes to the property owner. Again, I'd have to review the transcript of that particular hearing, but at the end of the day, the code case was moving forward. And even then, you had the original case, he was here, and then the extension. And then as far as the notice of today's hearing went to the property owner. So with that is what is before you, Madam Magistrate.
Attorney Dawson?
Yes. We are seeking an extension for the tenant to come into compliance with the soundproofing renovation for 6 months extension is requested.
The town's position with regards to that request?
We're here to confirm a fine. An extension was already given, and unfortunately, not a lot of effort was made on that extension. It's been since January. We're here in August now, so I would like to move forward with the confirmation of fine.
I'm not going to grant an extension. Again, you represent the tenant, and just so the record is clear, I don't represent either side. However, there could be a potential conflict in you speaking or your client wanting to speak on behalf of the owner of the property, considering they have a contractual relationship that is unrelated to the code enforcement case. So, and your client or yourself don't have any written representations from the owner authorizing you to speak on his or her behalf. And for the record, the owner of the property is not here in this hearing. So.
Correct. My client and I are not speaking on behalf of the owner, and I am here today to preserve my client's rights as the tenant. In terms of these fines, like I said, I haven't had an opportunity to review anything. Recently retained,
Right.
explained the excusable neglect.
Right.
So we're here to I want to get all this on the record, and then I'll proceed accordingly.
Okay. And what right are you preserving as it pertains to a property that is owned by someone else who was duly cited?
The rights I'm preserving for my client, the tenant, like I said, I don't know what the lease says. There may be a clause where the tenant is responsible for any fines or codes pertaining to the town of Pembroke Park. So,
And code enforcement hearings are subject to what Florida Statute Chapter 162 provides. So, in essence, what it sounds like, there's a private issue between your client and the owner of the property.
there may be, and there may be an issue with code. I have to review the file, see what's going on with the application process, what happened in terms of the delay. I have transmittals where it shows activity. Officer Ramirez is stating that there has been no activity, and I'm here to get all this on the record. I'll review the file and then act accordingly. I haven't been in this building since 2015. It brings back memories. A very good, dear friend of mine used to be the chief of code enforcement, James Tisdale. I don't know if you knew him, JT. So I'm kind of, he passed away. It was a very sad situation. But anyway.
Well, I do thank you, Attorney Dawson, and for the record, since we are on the record.
Yeah.
And I would probably ask the town and assistant town attorney, for the record, case number 9150, the property owner for this is 3192-4 West Hallandale LLC, Management Office. The owner of the property was cited. The attorney, Attorney Dawson, represents the tenant. The tenant nor the attorney are here on behalf of the owner of the property or with authorization to speak on behalf of the owner of the property as it pertains to this case being on for confirmation of the fine. Does Officer Ramirez or Assistant Town Attorney like to add anything for the record?
No.
Okay.
No, ma'am.
Seeing that there is no attorney here for this case and the respondent, which is the owner of the property, is not here on this case, we will we'll move on to the next case that has an attorney present.
Thank you.
You're welcome.
Morning.
No, we didn't have the case.
Oh, how you doing?
Good morning.
Good morning, Mike Pizzi, on behalf of Jeffrey Jacobs. I believe the two cases pending are 9026 and 9387.
Madam Magistrate, that's 11.1 and 12.1 under docket.
And Mr. Attorney, if I could, I think that my understanding of the status is this is his first hearing, and there has not been he's denied the allegations. There has not been a determination of lack of compliance or guilt, right? This is his first de novo hearing in front of the special master, correct?
Madam Magistrate, if I may respond?
Yes.
This is the first hearing where the case will be presented today, and then the Madam Magistrate will make a finding of fact.
I'm sorry?
Today is the hearing of which Madam Magistrate will make a finding of fact.
Okay.
And the city will present this case first, but there has been no prior, to my knowledge, these are the first time hearing on these cases.
There's been no resolution. He denies that on a number of grounds, he denies that there's a factual or legal basis for finding him in violation of the Pembroke Park Code under in citations 9026 and the other case 9387. So it's his position that there's.
Oh, Mr. Attorney Peasy?
Yeah.
This is the first time up, so the city or town presents first.
Yeah. Okay.
But you're moving to dismiss?
Yeah. Before we get there, I want to
Okay.
move Ori Tennis to dismiss on two grounds before we get to that. One is with regard to the first violation, 9026. It's our position that the town does not have jurisdiction. I can tell you, having had decades of experience with mobile home parks and been an attorney in a city that has only mobile home parks, dealing with this every day, that the town of mobile home trailers are treated like vehicles under Florida's mobile home statute, and the city, because mobile home trailers are treated. If you could ask people to just maybe, I can't hear. They can quiet down in the back because I'm having.
Attorney, yes, I agree. Attorney Peasy, can you slide over? Excuse me, members of the public, kindly, we are hearing a case. Please, no speaking in the audience because it picks up on the audio. If you do need to take a phone call or have a conversation, please do so outside. Thank you so much.
So we're moving to just regarding citation 9026. Florida has a mobile home park statute, and under Florida law, it's very, very clear that mobile home trailers are treated as like vehicles, and you're allowed to make repairs on your mobile home trailer, and that the city does not have jurisdiction to issue citations under the Florida Building Code. So the basis for dismissal is twofold, and that is with regard to citation 9026, number one, Florida statute and black letter Florida law is very clear that the city does not have jurisdiction to give a citation under the Florida Building Code to a mobile home trailer, just front and back. They don't. And in this case, the allegations are that he was making some minor repairs on a mobile home trailer, and the citations are all illegally and improperly under the Florida Building Code. So this should be dismissed outright without any further proceeding. It's very clear. Been through this 100 times. Now, the second thing I would note is that in this particular case, I think that there was an email sent from a city official acting, allegedly acting anonymously, telling the mayor and commissioners that they should target Mr. Jacobs, who's a commissioner in the city, and the only relevance of him being a commissioner, and he understands as a city commissioner, he's treated like everybody else, and is asking for no special treatment. But the only relevance of me mentioning him being a commissioner is because a letter was sent to the mayor and commission and saying you need to send people out there, send code enforcement out there to the commissioner's residence as some type of retribution or political payback to target him. And I'm going to be introducing that into the record. So regarding the first citation, succinctly, 9026 should be dismissed. One, because it's clear from the factual record that he was selectively targeted for political purposes, and I'm going to introduce this letter into the record. In fact, I'm going to hand, who's the clerk for these hearings? Do we have a clerk for these hearings to take documents?
Yes.
I'm going to hand up the following document. And, you know, having the mayor and commissioners instruct code enforcement to selectively target somebody for political reasons is a very serious violation of his property rights and his constitutional rights. And second, I think that, and then they went and cited him because illegally because they don't have any jurisdiction because it's a mobile trailer. With regard to the other citation,
If I may, Madam Magistrate, Mr. Pizzi, I think it might be best to take these two matters separate.
okay, then what I'll do is I will on those grounds I'm moving for an immediate dismissal of case number 9026.
Madam Magistrate?
Yes, you may.
Case number 9026 is being brought by the city's building official. So at this time, I think Mr. Steve Pizzillo is here and will present and handle the case on behalf of the town as the building official.
One more point on the motion to dismiss, and I'll conclude. Mr. Jacobs, and I'll refer to him as Mr. Jacobs for this hearing. Mr. Jacobs went to the former official, Miguel Nunez, and Mr. Nunez explicitly advised him on behalf of the town that he did not have to get a building permit from the city to do the type of repair he was going to do on a mobile. I think that for that reason, the city would be stopped from telling him, having the former building official explicitly tell him that you don't need a permit for the reasons we just talked about. They would be stopped from having a new building official come in and then have people, officials in the city have the new building official politically target him and go out and give a citation. It's unfortunate. It's a violation of the law. I think the best thing we could do, quite frankly, to protect everybody's rights, and certainly to avoid, if you choose to go forward and not dismiss this, certainly to avoid litigation involving all the city officials and inspectors involved who've perpetrated this. Certainly, I think it's in everybody's best interest to simply dismiss this and move on to the next case. Thank you.
Madam Magistrate, briefly.
Yes.
This matter is being brought by the building official under the building code. Many municipalities would have building cases and as well as code cases. So this is what you would consider a building case. So as far as all the authority and jurisdiction is within the building department, and that's where the genesis of the violation is, and that's where everything is as far as that is concerned. So that's where this would be considered a building case, as what Mr. Pizzi was saying before, as far as code enforcement's involvement in this particular case, it is none, because again, this is a matter of the jurisdiction of the building department, which our office, and as well, really, and just in general, there are few offices that have very unique authority within the cities, building official being one of them, having that ability to enforce the Florida Building Code. So as far as that's concerned, that's why we defer to those unique powers of the building official.
Thank you.
Good morning, Steve Pizzol, interim building official for the town of Pembroke Park. This is a case where work was performed interior and exterior without the permits being applied for. Yes, it is true, it is a mobile home under the jurisdiction of the Department of Motor Vehicles. And I will enter this into the record. This is a derogatory from Department of Motor Vehicles stating these types of construction and repair, which is considered major, may require permitting, and owners should check with their local jurisdiction to determine permitting requirements. And the major repairs are when you're doing electrical, plumbing, and structural type work, which is all done on this premises. As far as the statement that there is no jurisdiction under the building code, this statement also goes on to say that, you know, you're going to check with your local permitting department, which is the building department. And when you're dealing with building codes and the jurisdiction of the building official, it's never a straight line. It's always shades of gray. You have to sometimes connect dots. For example, existing buildings is under the existing building code. You would never go to the building code unless the existing building code sends you there. In this case, when they're sending somebody to the local permitting department, it's sending you to the building code. Also in this city, we have, I discussed this matter with the building manager this morning, asking him how many permits have been issued to remodel and fix mobile and modular homes in this town during his jurisdiction here, and he said thousands.
I'm going to object. If the city wants to call the building manager or anybody else to introduce them, they could do it. And second of all, what the city did in other cases is completely irrelevant. I think we're here on this case, and I think it's unfair to bring in evidence as to what the city's done with other cases.
But in this case, we are presenting what the city has done in the past, and I have continued to do. Now, during the time of Mr. Nunez's jurisdiction here, I believe it's 16 code cases that were brought forth for the same type of violations. He also approved and issued hundreds of permits.
And Mr. Building Official,
Yeah.
Let's stick to
Sure.
this case. Attorney Pizzo, I'm going to deny the motion. It's really a weight argument. You did in your testimony reference third parties who aren't here. So, but it is noted for the record. But Mr. Building Official, let's try to stick to what you did, what you heard. You know, if you want to confirm with other testimonial evidence in support of what you did and your
And as the authority having jurisdiction, it was my opinion that these modifications, renovations, whatever you want to call them, required permits.
Okay, and I have a question because you referred to something and you had something in your, I didn't quite catch the title of the document or what you were referring to.
It's from the Florida Department of Highway Safety and Motor Vehicles, Division of Motorist Services, Manufactured Homes, and it says Mobile Manufactured Home Repair and Remodeling Guidelines.
Okay.
It does talk in here about how if you are just replacing vinyl siding and you're replacing windows like for like, you don't need permits. But this case went far beyond that.
Okay. Anything else you want to add? Because I think, yes, you may. Well, 1 second, Attorney Pizzi. Town Attorney, do you have any questions for
No, again,
the official?
well, this is the building official's case.
Okay.
They are the ones presenting the
Okay.
case.
Question, yes, Mr. Pizzuto.
Attorney Pizzi, in the microphone, please.
Yeah, Mr. Pizzuto, you said that you read a section about the fact that they are treated as mobile transportation devices, and that they should check with the local jurisdiction as to whether or not a permit is needed. Could you read that to me again?
On page 5, under level 2, major repair or remodel that substantially impairs the structural integrity of or safety. Item 4 starts, and I'll give you the extended version. If the repair or remodel involves major electrical and plumbing work, these types of constructions or repair may require permitting, and owners should check with their local jurisdiction to determine permitting requirements.
Now, you do not dispute the fact that Mr. Jacobs did exactly what you just said and checked with Miguel Nunez, the building official, in compliance with the statute, who told him that a permit was not required. So my only question is this. You do not dispute the fact, as you stand here today, that Mr. Jacobs checked with the then building official, Mr. Nunez, in compliance with the statute, and Nunez told him a permit was not required. You don't dispute that, yes or no?
I can't dispute something that I have no knowledge of.
Okay, well, let me ask you this question.
If I may, just Mr. Pizzi, Madam Magistrate, it's Mr. Pizzi. Am I correct in understanding that you're talking about Mr. Nunez's alleged oral, again, hearsay statements? But as far as your objections are over the determination of whether it be Mr. Nunez or Mr. Pizzi. And let me clarify, because I'm not looking to hide the ball here, because Madam Magistrate has the authority to hear whether it's a violation or not a violation. And if you are objecting to the interpretation of the building code by the town's building official, under, was it 773, 775?
Are you representing, I thought the building department presented their own case. Are you, yeah.
Understanding, sir.
Yes.
But if this is, again, a point of order for the statute, but if you're objecting to the interpretation of the building code, then that's not properly before Ms. McKinney. That would be an appeal to the Broward County Board of Rules and Appeals.
That's not what I'm doing.
Okay.
Mr. Pizzuto has said that under the statute, you check with the building official to see whether or not a permit's issued, and that's what you're supposed to do. And Mr. Pizzuto has had every opportunity over a period of months to simply call the former building official, one of his mentors and instructors, and simply say, Mr. Nunez, you were the building official. Did you tell him this was not a major repair? And he didn't require a permit. So, this is willful ignorance. So what I'm saying is that I think that the fact that it also goes to the selective targeting. Former building official Nunez told him he didn't need a permit because it wasn't a major repair. They get a letter from somebody, we're almost certain who it is, I think we know who it is, stating, Commissioner Jacobs, go cite him, even though the former building official said he didn't require a permit. They bring in a new building official, and he comes in and goes out there in compliance with this request to target him, goes out there and cites him. So I just want to make sure that record's clear. Let me ask you another question. Mr. Pizzuto, what is where in the town of Medley Code does it define major repair? Is that completely subjective? So my question is this, and this goes to the underlying facts.
This is town of Pembroke Park. You mentioned town of Medley.
The town of Pembroke Park, I apologize.
Okay.
The town of Pembroke Park. The decision in the town of Pembroke Park as to what constitutes a major repair on a trailer is entirely subjective. Yes or no?
The town of Pembroke Park, with the decision on major or minor repairs for mobile and modular homes, is the same as the building code. They're both state statutes that we enforce. In this case, there is a whole document from the Department of Motor Vehicles defining what is major and minor.
Did you see, could I just get Exhibit 1 back, my exhibit, if you have it there?
Yes. And it's part of the code file.
You know who wrote this, don't you?
No, I don't.
Okay. But you saw this, right?
I was CC'd on it. I received a copy of it.
So just so I understand the timeline from a factual perspective. Prior to receiving this, you were CC'd on this anonymous email stating that you would agree this makes a bunch of political statements about a commissioner, correct?
Hold on, Attorney Peasy, for the record, do we want to label that?
Exhibit 1, yeah.
Okay.
So just regarding, you realize that Exhibit 1, which you were copied on, makes about what he's done or not done as a commissioner, correct?
First of all, a point of clarification, this was sent through the mail, it wasn't an email. Second of all, it talks about work that was done on the property. The only thing that talks about political is the fact that they mentioned Commissioner Jacobs in it.
So let me go back for a second then. And you've been, obviously you're under oath for this proceeding, we understand that. So everybody was sworn in at the beginning, I'm sure. So you state that the only thing political in this referral was it mentions Commissioner Jacobs. So let me go back and look at this.
Mr. Peasy, I don't mean to interrupt, Madam Magistrate.
Yes.
The only concern that I have is the normal procedures, right? Because we started off on the motion to dismiss.
Right.
Where, and I'm not the defense has entered evidence, which the town's not objecting to.
In support of the motion, I'm presuming.
So are we on the motion or are we the actual hearing?
We are still on my understanding is that.
No, the motion was denied. I'm cross-examining him on.
Under the normal procedures. Because what Mr. Peasy doing is cross-examining.
When we haven't heard.
When we haven't heard the testimony.
I thought that was the testimony.
Well, the normal procedure is at the beginning when, again, we heard the motion first for Madam Magistrate, if I may, that the town, again, this would be the building official, would present the case first. Then you would have the opportunity to cross-examine.
He did. The motion to dismiss was denied, and the building official said that he found, in his opinion, that these were major violations that required a permit, and then he concluded.
Madam Magistrate, that's your determination.
That's not the sequence of events. And to be clear, Attorney Peasy, you recalled I indicated that in the order of procedure or process, when it's a first-time case, the town presents first. You made Ori tennis motions. And for the record, with regards to responding to some of the points that you raised with regards to your Ori tennis motion, with regards to the jurisdiction and the email, the basis for dismissal, the email, and then you raised equitable estoppel, right? Those three grounds were the
Correct.
basis of the Ori tennis
And the
motion.
motion was denied by yourself.
I did not make an oral pronouncement.
Let me ask a question, then, just so the record is clear. I want to make sure the record is clear.
Okay.
My question was interrupted. I want to ask whether or not I am being, that you are instructing the witness not to answer my question.
I'm not.
And I'm getting clarification. You've raised your 3 points. Mr. Building Official is responding.
Okay.
And if the Assistant Town Attorney
Well, there's a question pending. I'd like you to answer.
No,
my question answered.
there is a question pending, and I do apologize, Mr.
And
Peasy.
you've interrupted my proceeding, and you're not letting the question be answered, and I think it's a due process violation. I will respect and honor your honor as a special magistrate, and I will respect the town attorney, and I will stand here and be silent. It's my understanding that he's not being permitted to answer my question on cross-examination.
If I may, that's we're not instructing the witness not to answer. My concern was procedural when, as far as what was, again, to advise Madam Magistrate as far as the procedures are concerned. So again, I defer to you, but no one instructed the witness not to answer. But as far as the record, again, it seemed to be going off as far as the motion versus the presentation, which is why I wanted to advise the magistrate. Mr. Pizzi is correct. I did not willfully mean to interrupt a question. But again, as far as the objection as to the proceedings was also timely to allow the building official, again, as the presenting authority, to present, and then Mr. Pizzi can ask any questions. If you would like to instruct the witness to answer his pending question, please do so.
Right. And before doing so, I just want to be clear on both sides. Do we all agree that we are still on the motions raised by Attorney Pizzi?
My recollection was that the motion was denied, and that I can remember from 10 minutes ago. My recollection was, listen, Your Honor denied the motion and asked Mr. Pizzuto to make the presentation, and he came up and he said his presentation was, he thought these were major repairs and made without a permit, and then I started cross-examining.
If, Madam Magistrate, you did make an oral pronunciation on the motion, Mr. Pizzolo.
The motion to deny Attorney Pizzi's
Correct.
motion as to the hearsay that the building official spoke of with regards to other cases. That motion was as to that. He made a motion with regards to him bringing up hearsay. I ruled on that aspect, and I instructed Mr. Pizzi. I denied that, and I stated to Mr. Attorney Pizzi that in his presentation, he too inserted hearsay. And then I instructed the building official to please to stick to the facts of this case. If he, what he did, what he saw, his interpretations, his expertise, et cetera, and then if he's adding on to, that ruling was as to your objection to his hearsay. So the record is clear. Does everybody recall now? Attorney Pizzi, you recall that?
No. That's not my recollection.
That is what I said.
I will respect your rulings, but just from my record is that...
You made it, not to cut you off, you did make an objection and you raised hearsay. Do you not recall that? During the building?
Yes, but my recollection is that you denied the motion to dismiss, and let's be clear. The motion to dismiss, well, these meetings are recorded, so the motion to dismiss was denied. So my question is this. I think that, we've taken a lot of time on this. I asked a question. I'm in cross-examination. Either I'm going to be permitted to continue the cross-examination or not. I'll respect the court's ruling. Please let me know.
Okay, again, because I said it. And so the motion denied was as to your objection to the hearsay based on what the testimony of the building official. Now, what I am inclined to do is if we're about to wrap up this portion of the motion to dismiss, as Attorney Pizzi has raised, and from there, we can go into the presentation. Attorney Pizzi, your question on the floor is?
Okay, you just testified that there was nothing political in here other than using the word Commissioner Jacobs. You remember that from a second ago?
Yes.
Mr. Pizzi, not to interrupt you, because I do want to move on. I do want to address the Ori tennis motions based on the three grounds that you raised. You can ask him that question. That question is more appropriate in the case presentation.
What would you like me to do?
I would like to hear from the Assistant Town Attorney as to the Ori tennis motion, the three counts raised by Attorney Pizzi on behalf of the respondent, because we're still kind of like in that pre-motion phase or pre-trial phase if this were an actual court proceeding.
Well, as Madam Magistrate has stated before, the building department, under their exclusive jurisdiction, is bringing forth this matter. The only comment that I added to the record to clarify was if they are objecting to an interpretation of the building official under Florida Statute 553775, then that should go to the Board of Rules and Appeals. That's not properly before you. That's the only additional comment, because again, you're not given that exclusive jurisdiction, the magistrate, to make a ruling on the application of the building code. And argument has been made and brought forth to judges as well, as far as that way of appealing the decision of a building official. So that was the only clarification I added to the record.
Okay. And what's the town's position with regards to the second point raised by Attorney Peasy with regards to the email, which I believe we are calling Exhibit 1?
That's right. The fact.
Well, I'll say Exhibit 1. I don't know if it's an email. The two-page document that Attorney Peasy presented.
Yeah, the question for the town, the attorney would be whether or not it is a town attorney of Pembroke Park's position that it is permissible to intentionally issue code citations for political purposes and political targeting. And I'm sure they'll have an answer for that.
Madam Magistrate.
You may, but I have a question. More specifically, Attorney Peasy, your legal basis with regards to Exhibit 1 is specifically what?
Is that it's improper to selectively target people based upon political positions, exercising their First Amendment rights to run for office and take and exercise their rights as a commissioner and take political positions. That's unconstitutional. It's a violation of Florida Statute 42, USC Section 1983, as a First Amendment violation, as a due process violation. And I believe that this memo demonstrates that there was a request to target Mr. Jacobs politically because of what he did or did not do and say as a commissioner. And the record is also clear, as Mr. Pizzuto's acknowledged, that he, you know, the former building official told him everything was fine. The new building official is copied on this saying this memo to target him politically, and then he comes out there and issues the citation. So I'm not going to belabor this, but based upon the record before you, we ask that the Ori Tennis motion be granted.
Okay. Anything to counter with regards to the motion? Other than what you've already said as to the interpretation, and anything with regards to this correspondence?
Which is that we defer to the authority of the building official.
Okay. Attorney Pizzo, I'm going to deny the motion. The interpretation as to the Florida Building Code rests with the Board of Rules and Appeals. The Exhibit 1 on its four corners does not demonstrate or show selective enforcement. And the basis of equitable estoppel is also denied based on what's been presented. So at this juncture, we will have the presentation from the top. Mr. Building Official, so you will introduce the case in the matter.
Since I don't have that, I'm going to ask the code manager to do that for me, to put all that stuff in.
To read in the case? Is that what
Read
you
in the
mean?
case, yes.
Okay.
I have an objection.
Okay.
My understanding is that Ms. Ramirez is in some form of litigation with Commissioner Jacobs. That she filed some form of a grievance that we're not going to put on the record today. It will be inappropriate. But I will simply state it's my understanding, as the city attorney is aware, that Ms. Jocelyn Ramirez filed some form of a complaint or grievance or litigation against the commissioner that's under some form of investigation. And I believe there have been cross allegations, and I think that based upon that, while she's got a formal grievance pending against the commissioner, which could lead to further litigation, I think that she has an absolute conflict of interest and should be recused from any further action on this while she's in some form of proceedings with Mr. Jacobs. I would simply note that I can't, again, it's up to the city attorney and Ms. Ramirez and Mr. Pizzuto to get their own, to either get their advice from the city attorney or get their own independent legal advice. I am simply stating that I think that there is a conflict of interest and that there should be a recusal. And I'm not going to say anything else about it, but I simply want to put that on the record.
And all I'm asking her to do is read from the computer in front
Right,
of her.
hold, Assistant Town Attorney, is there an objection from the town with regards to the request? Anything outside of code enforcement isn't before us, nor is the magistrate privy to. Building official, you're asking the matter to be read.
If I may, Madam Magistrate, I think the issue very simply stated is, as far as reading in the case, we've already read in the particular case.
Okay.
As far as the only other issue would be, Mr. Pizzi would be notice. I don't think Mr. Pizzi is objecting to notice. Is that correct?
No.
I'm sorry?
Are you objecting to notice?
No, he was given notice, and I'm not saying he did not get notice.
I think to the extent of whatever that Mr. Pizzillo was asking to be presented would be limited to notice, and as far as the violations on record, which are in the city's file, which I think Mr. Pizzillo can go ahead and reiterate through his presentation, and as well as, authenticate and we're moving the city's file into evidence. And as far as I think that's the extent of the request. So I think we could avoid any issues. Again, if notice is not being objected to, we have the notice of violation is in the city's file. We're moving that forward as evidence in this particular case and submitting that. Would that resolve any issues, Mr. Pizzi? Thank you, sir. All right, so that's how we'll proceed.
So I'll begin my presentation.
So I will read it into the record?
Go ahead.
Okay.
Well,
Madam Magistrate, I think with the agreement of council and understanding that resolves all the issues, then I would, again, procedurally think it would be appropriate at this time for Mr. Pizzillo to give his presentation following any questions that you might have and any questions and cross-examination from Mr. Pizzi.
right, and what I was going to also state, we do have a large, there is a large screen if you're able to, if you need to move the lectern closer, so that we have a clear record. We are on case number 9026, and this is just for presentation and edification. Attorney Pizzo, the violations at issue pertain to installation of multiple windows, exterior repair of west side walls done without a permit, and installation of windows also done without a permit, and performance of a major repair or remodel, including but not limited to kitchen and bathroom, interior wall finish, electrical and plumbing, and that an after-fact permit and inspections are required for such. That is what's in the file. This is what's before me that Mr. Pizzo is going to present upon.
I thought.
Pizzi, excuse me.
I thought his presentation was that he relies on the record and says he thinks it was a major repair. That's what I thought.
Well, there's 3 detailed items. So I just want, and for the benefit also for your client, because he's a part of this hearing as well, just so everyone understands, those are the 3 cited violations.
I understand.
Okay.
Okay, let me start off with how I became aware of this, and I became aware of it when a Channel 10 reporter showed up in the parking lot and asked me for my comment on what's presented, which you have as Exhibit 1. I had not received it yet. I actually received it a couple days later, so that was my first contact with this. I also have to put on the record, since he's saying that it's a political hatchet job, no politician from this city contacted me to go out there and cite him. Just need to put that on the record. This was not selective enforcement. So there's two things that are going on here. One was the initial letter, which I deemed felt needed permitting. Yes, the Department of Motor Vehicles does say ordinary repair and remodel, which is a replacement of windows for like.
And building official PZ, excuse me.
Pizzello. He's busy. I got a couple. I have a couple more letters at the end of it.
I'll just call you Mr. Building Official.
That's fine.
Now, with regards to the documents, that was the 2-page documents?
Yes, the one that you have is Exhibit 1.
Okay.
And the replacement of vinyl siding for like. The problem is that it wasn't just replacement of vinyl siding. It was also, as you could see, the sheathing was missing off the house. It looks like there may have been some framing repairs. That's all structural in nature. It does require permitting. Later on, additional pictures became available under a FOIA request from, I believe, Channel 10 again, and it showed additional work being done on the inside of the house, bathrooms, kitchens, et cetera. That goes under the major repair of this document. So that, so the code, this was amended to include the interior portion. Prior to that, it was just the exterior portion because that's all we had the pictures for. And in my opinion, as the authority having jurisdiction, this is something that this town normally does, normally cites people for this work, normally requires permits, and normally goes out and does inspections on a daily basis. Thank you.
Okay.
Mr. Pizzito, these photos that were obtained by a FOIA request, do you know who put the FOIA request in?
I believe it was Channel 10.
Okay. And do you know who had the photos?
Yes, I do. So for edification, my wife is the town clerk here, and Mr. Jacobs had sent her photos, and she had them. And at a council meeting, it came out that from the city attorneys that it was part of, it could be requested by the public to view the photos.
So just so I understand this, and we have our record here. The photos were, so just so I understand this whole setup and how this got done.
I object to that.
Well, you don't have a right to object, the attorney can. I just want to understand what happened here, so the record's clear. But I'm sorry, I don't have a court report about it. These are recorded, correct, anyway, right?
Yes, they are.
They're recorded, okay.
And if, again, for any appellate purposes, you'd have to transcribe it yourself.
Okay, but it's recorded. We can transcribe the tape recording. Okay.
That's what you would have.
So my question, yeah. So my question would be this: we're saying that somebody put in a FOIA request for photos that just happened to be on the cell phone of the city clerk. I want to understand how these photos, these after-the-fact photos, came to fruition. The photos were on the personal cell phone of your wife. Is that correct? I just want to know where they came from.
They were on her cell phone, which had been sent to her by Commissioner Jacobs.
Okay, so my question is, were they on her personal cell phone or a town cell phone? I can't hear what I'm saying.
Excuse me, members of the public, kindly, if you need to speak, if you could please step outside. We're in the middle of a hearing. Thank you.
I can't answer that question. I don't know. I don't know if she even has a town. I don't know where her phones are from.
Okay, so just for the purposes of authenticating these photos, we don't know whether or not
I have a question.
Yeah. Just seems a little strange to me, that's all.
Just for the we're clear, we're not talking about, are we talking about the photos attached to Exhibit 1? Page 2, Exhibit 1? Are we talking about the photos? And I'm looking at the case file, Counselor, just so you're aware. There are photos in the case file which show the interior of a structure.
Yeah, so just,
Okay.
yeah, just to be clear, the photos from the interior, which we don't have anyone here to authenticate them, but those photos were on the cell phone of Mr. Pizzuto's wife, who's the town clerk. and they weren't taken by code enforcement or any type of reasonable, Fourth Amendment privilege inspection of Mr. Jacobs' home. So there was part of the basis of the violation were predicated upon photos that your wife had on her phone that she contends she got from Jacobs, correct? Yes or no?
Yes, and if you look at the pictures, you will see that Commissioner Jacobs is in one of the pictures doing work.
Okay. So now, you didn't give the citation until you got the photos from your wife, correct?
That is incorrect. It was amended. The original citation was based off of the original photos that were sent through the mail.
So the amendment was based upon photos that you got at some point from your wife's cell phone, correct?
No, I didn't get them from my wife. I got them through a request, or there was a request made, and they were distributed.
Okay, but the photos that, when they complied with the FOIA request, they came off your wife's cell phone, right?
Yes.
Okay.
Or the ones those, I don't know where the originals came from.
Oh, you don't?
No.
Okay, well, then they're not properly authenticated. Then we would object to the introduction of any, if you're telling me that you can't authenticate these photos, hang on, you didn't take them, and you don't know where the other photos came from, the whole case should be thrown out because those photos are not properly authenticated, and I'm making that argument in closing. But let me just move on, because I want to wrap this up. There's a lot of people waiting. Now, the decision to amend, you made that decision after your wife provided the photos in response to the Channel 10 request, right?
Yes.
Well, how did Channel 10 know that there were photographs on your wife's phone?
Because at a commission meeting, it was brought up, and originally my wife went to the city attorney and said, I believe it was, do I need to answer that? And he said yes, and she said, yes, there are additional photos that I have. So that was in an open commission meeting.
Okay. So now, you got the photos that came off your wife's phone and amended the charges. And the charges, the amended and unamended charges, unlike a typical case where someone alleges a violation of the building code and you look at the building code and they either didn't get a permit or they did get a permit. In the case of the mobile home parks, in the case of the mobile transportation devices, you've testified that you don't have to get a permit unless you check, excuse me, sir.
I didn't say anything.
You'll get your chance. You don't have to get a permit unless you check with the building official and they tell you it's a major repair and a permit's required. And you don't know, if you don't dispute that didn't happen here. And second, you have to make a determination as a building official as to whether or not you believe it's a, quote, major repair. In other words, you have to decide as the building official that there's a major repair, and if you decide it's not a major repair, they don't need any permit under the mobile home statute. Now, let me ask you a question, without going into any detail. Is it fair to say that you were aware of the fact, when you made that determination, that Mr. Jacobs had been in contentious litigation with other city officials, including your wife? Were you aware of that?
Yes, since she's being personally sued, yeah, I'll put it on the record, but that has nothing to do with this case.
Okay. I have another question.
I want to answer that question first. The pictures that were shown to me, which he is now contending as to whether they're legal or not, after those,
For the record, are we speaking of?
we're talking about the original, Exhibit 1. Once we received that, we did go out there and we looked, and it was clearly obvious from the outside of the building that work had been done. Clearly obvious.
And I apologize to interrupt you, building official. With regards to Exhibit 1, when you received that, I believe your testimony is that Channel 10 News or Anchor, whomever, handed you that piece of,
He handed me a copy of it and asked me for my comments on it, which I didn't comment on at that time, and I still haven't commented. I received my copy of it in the mail a couple of days later.
okay. And is your testimony that you went to the site?
Yes.
Okay.
So here's my question.
And what did, I'm sorry, Counselor, and what were your observations?
My observations were that the work that was visible from the outside was consistent with the pictures.
And that work was?
Well, in other words,
What did you see?
we saw new vinyl siding, we saw new windows, and in the picture, you could see that vinyl siding and sheathing had been removed from the outside of the structure in a certain area, and now on that same area was new material.
Okay, and Attorney Peasy, you will have a chance, because there's been a lot said, and I want, clarity, but I will definitely give you an opportunity, because I have a few questions. I don't know who has Exhibit 1, but I'll take a look. With regards to the images shown on page 2 of Exhibit 1, were those images visible from the exterior when you went to the site?
The area that is in one exhibit, which in one of the pictures which shows the structural framing, had all new material over that area. So that was, the outside was visible. It was clear that work had been done. In the picture, the sheathing is missing. Sheathing and framing require inspections, require permits, structural in nature.
Who has Exhibit 1?
I believe that was,
No, it's not here.
No, I gave it back. I placed it.
Mr. PZ took it back. Yeah.
here.
No, I believe I placed it back here. You can ask the attorney about it.
Oh, that would be me.
Apologies.
You want to just label it so we know that's the official one?
Yes.
Okay, we're going to label it with.
One.
Mr. Building Official, I'm going to hand you, for the record, back Exhibit 1. Your testimony pertains to page 2 of that exhibit. Can you, while holding that, and describe your testimony in line with the 3 photos shown there in terms of what your personal observations were?
My personal observations, when I went out there, the work had already been completed, but you saw all new material over those areas.
Okay. And the areas specifically, and I'm looking at the amended citation for the record, and those areas would be, I'm going to read the, installation of the multiple windows. That was visible on
Yes.
your inspection.
Yes,
Exterior repair of west side of the wall.
yes.
Okay. And what about major repair remodeling?
That became evident when the second group of pictures was made available.
Okay.
Even though on the first group, there is question as to whether in my opinion now, it did go into the major repair because it was structural in nature.
Okay. But at the first time that you went to the site after getting Exhibit 1, your testimony is that per the amended violation, items 1 and 2 were observed.
Yes.
Okay. Counselor,
Steve, did you ever, in light of the fact that
we'll leave it here.
just 2 questions, then I'm going to wrap it up. Did Mr. Jacobs ever tell you that Mr. Nunez had told him he didn't need a permit? Yes or no?
No, we did not.
In light of the fact that prior to you issuing these citations, in light of the fact that you had to make a determination as to whether or not a permit was required at all, and there was a dispute about that, in light of the litigation that you just mentioned, where you said that Mr. Jacobs had filed a lawsuit or something against your wife and there was litigation, did you at some point...
Attorney Peasy, just for the record, can you tie in the relevance?
Yes, I can.
Okay.
Because I think, well, on all these cases, the credibility of the witnesses and their determination is an issue. So I think it's, and bias is always relevant in any cross-examination. So my question is, did you get any legal advice? Without telling me what it was, did you get any legal advice from the city attorney's office or from any other body as to whether or not it was appropriate for you to make any determinations on this property in light of the litigation you mentioned? Yes or no?
No, I did not, because as the city attorney's office always says, it's up to the authority having jurisdiction. What I did do was I brought in 2 building officials from other towns because of the sensitive nature of this, and I asked them.
I'm going to object now, because now we're hearing for the first time at this hearing that other building officials, that he relied upon other building officials from other towns because of the sensitive nature of this. What was sensitive about it, and what other building officials did you talk to?
Building official from Lauderdale Lakes and the building official from Lighthouse Point, and they did not. I brought them there to find out if they concurred with my decision, which we agreed with my decision, which building officials will do from time to time, because we can't, in most cases, go to a city attorney's office.
I'm going to object to any hearsay testimony about what other building officials said or did not say, who were not listed on any of the reports we've been given. No. Is there anywhere in any report that you've produced where you said that is today the first time that you've said that you relied upon other building? Can you point to any of the documents in the file that put Mr. Jacobs on notice that you contacted other building officials to double-check your work on this case? Yes or no?
I did not rely on other building officials. I already come to my decision. It was a decision also to say, bring somebody else in, let them see if they have any objections to it, which none of them did.
Objection. Here's my question. Point to Her Honor and the attorney, a single piece of paper in this file that says that you contacted other building officials to see if they concurred. Is there any piece of paper where you said that? Yes or no?
No, because it's not relevant.
Okay, so hang on a second. It's not relevant whether there was a concurrence from other building officials.
No, because
yet, you chose to contact them. You chose to contact these other building officials because you wanted to know, because you weren't sure because of the sensitive nature of this case. You chose to contact them, and now you're saying it wasn't relevant. Well, if it wasn't relevant, then you shouldn't have contacted them. Either it was relevant and you needed to, and you thought it was appropriate for them to give a concurrence. If so, then that should be in the report. Building officials in other cities checked on this, or it wasn't relevant. And I would note that none of that's in any report. What I'm going to be requesting is the following. My cross-examination's done at this point. I'm going to be there's a lot of people waiting, and I want to note that I'm in the middle of a totally separate town where I'm a city attorney who was sued in an election contest, and I'm going to have to attend a hearing on that very, very shortly because they have to make a decision on the ballot by today. So, and I'm going to ask that the second matter, this is my first time up here, I'm going to ask that the second matter be continued so the other people can have their cases heard. I feel bad for them. And also, I'm going to be bringing back, so I'm going to request that the second case be continued so other people can go and I can get prepared. It's my first time up. And I would note that I would ask that the presentation of the defense case be continued to that date so I can bring Mr. Nunez, because one of our defenses will be that the prior city building official told him he didn't need a permit. So I'm already moving to continue the second case. With regard to this case, I'm asking that we continue my presentation for due process purposes, because Mr. Pizzuto has said now for the first time that he contacted other building officials. So based on what I've heard in this hearing, I'm asking that you allow me to present my case at the next hearing. And I will tell you that, I've been doing this a long time. I intend to present a very streamlined defense, and the other case should not take that long. So I'm requesting that we come back at the next proceeding.
Is there an objection from the town, starting first off with continuing case number 9387, since that hasn't been heard? Is there an objection?
That case was already continued, and the property owner is here, so it will be up to the property owner to come and represent.
For 9387, is that the Madam
Those are the
Magistrate?
two cases, correct? 9026
26 at the
today.
and that we postpone 9387. It's my first time up, my first time here. I think that's just fundamental due process would require that, and I think we can streamline it the next time. I understand, but you know what? It may inconvenience some people, but the city's here. The property owners live in the city. I have to attend to another urgent proceeding. As the attorney, I'm sure should understand. So I will rely upon the fairness of Your Honor, and you're a very fair person.
Mr. Palazzi Waldi is the property owner. He's here on the audience.
Whatever is convenient for the town, we okay with.
All right, if you could just maybe come put your name and on the record, so it's not some distant voice, sir.
Waldi Polizzi for Rocky Enterprise. Whatever is convenient for the town, whatever works, it's work for me too.
Your attorney is asking for a continuance.
Is he representing you?
Yeah, they renting the property, so I'm here just, he doesn't represent me, but
You object to the continuance?
I don't object if you don't
So,
object.
Madam Magistrate, as to if we can do it just in piecemeal, 9026. The defense is requesting to present its case at another hearing.
No, I
That's
think he said that for 9387.
Oh, we're doing 9387 first?
Right, 9387, because this gentleman is here, and not to have him wait any longer. Does the town have an objection to rolling that over or continuing that? Attorney Peasy has another legal matter unrelated to this case to attend.
Mr. Gustin, this is your case. It is first time up. And if I may so proffer, is this if correct, I believe that the case itself, the banner signs were removed. I think the other sign was removed, and the only
Correct.
issue actually outstanding is the banner on the last trailer.
That is correct.
So if that's removed, then at least the case would be in compliance. Is that correct?
It's not completely in compliance.
Well, once that banner is removed.
Yes.
Okay, it would be.
Yes,
And then at
correct.
that point, the only, once it's in compliance, came after compliance date, it would be then up to the town to either comply it, or we can go for a finding of violation, and then any future violations or a repeat violation. So, Mr. Gustin, do you have an objection to that?
No objection.
Okay.
I'm sorry, is the property compliance now, or you're gonna remove the banner because this is?
We're going to address that at the next hearing, but I get it, I heard.
So it's not in compliance.
All right, so Madam Magistrate, that's 9387. Mr. Gustin has no objection, and the property owner has no objection. So we'll set that for,
Okay, so that matter will be rolled over to next month? Or continued? Notice to be sent in the mail?
well, the only thing is, if we could, Madam Magistrate, since you've substantially heard arguments, at least on the one case.
On the one
926,
case.
Right, that would have to stay with you. So if you want to keep this with you, then the only thing we'd have to do is schedule it for when you come back.
Right.
Leave it as
well,
every
I'm
other month.
speaking as
Yeah,
to
we want to keep it with Your
937.
Honor, because you heard the arguments. And
No, but I'm speaking on 937 because there's a gentleman here. So
Yeah,
if
for
you-
9387, but keep
Right.
both with you is what I think we're talking about.
I just hear the cases and.
Yeah,
and give-
I think,
On 937, the city's not objecting, the owner's
937.
not objecting, and it may resolve itself. So we'd like to just push that off for the next proceeding.
all right.
That's my question. I just want to know, does the town have an objection as to continue 9387? No objection?
The answer was no objection.
Okay, so that your continuance is granted.
Okay, great.
So the only question then, are we going to continue it 30 days, which would be Mr. Hippler, or we want to continue it to your next hearing, whatever amount of days that might be, 30?
We would request to just come back in front of Her Honor. She's heard everything, and
Yes.
we don't expect to take all day with that. We expect
No.
to streamline that. So I have to go on an urgent matter. I'm sure you can understand, Mr. Attorney. And we're in the middle of an election contest. But I need to, and I think that all that's going to be left on that is for me to present my case, and I'm just not ready to do that right now.
So if anything, Without objection, Madam Magistrate, would you want to put it back on your agenda?
Yes,
Or-
we can.
All right, so,
yeah.
so
So for, not to cut you off, so.
You're earning your money, you're earning your keep today. You're earning your money today, Mr.
I do that every day.
Park does have two special magistrates. So what will happen, Counselor, is that the matter will be stayed and continued to a future hearing date.
What's that date? If we can just announce it now.
If you tell me now, I mean, we're going to get the notice, but I'll be on record that I know when it is.
Correct. That's exactly what I'm going for.
The next day is
I can't say I didn't get the notice,
18,
right?
2024.
When?
September 18, 2024.
September 18th.
Okay.
So September 18th for 9387, and then we could talk if we want a special set or do something else. But as of now, that's the date.
If we want to do a special.
Just for the record, this is just for that case, right?
Correct.
9387.
And then for
And will it be with Mr. Kepler?
so September 18th. So 93, Madam Magistrate, would it be your order that case number 9387 is continued to September 18th? I mean, September
Yeah.
18th. I got it right. Make sure.
That's next month.
Is that you, Madam Magistrate?
That is not.
Well, that's what I'm saying. That's where I was saying. What's the next one for Ms.
That
McKinney?
case hasn't been heard, so you want to keep it for,
Given the nature of the proceedings, it would be best to keep everything together.
okay, then let me give you the other date.
Ms. McKinney's next hearing date.
That would be October 16.
October 16th.
Okay, for the record, we are on actual notice that we have to be here October 16th for the 9387 hearing and also for the continuance of the state proceeding in 9026. And we are on notice, my client's on notice, the property owner's on notice, and we'll be here on October 16th.
Is that your order for 9026 to continue?
Yes, he's
Okay.
requesting a continuance, and so the matter is being continued to the 16th of October.
Understood.
Okay, we'll see you on October.
October 16th. If you want to schedule it earlier, then we can try and organize that, but at least October 16th.
Okay, thanks.
Thank you.
Thanks, Your Honor. Good to see you.
Pleasure seeing you, Counselor.
Yeah, just say one thing too.
Yeah.
As the owner, I'm
Only as the scheduling, sir. Unless, Mr. Pizzi, do you have an objection with the property owner making a statement?
I have no objection.
Thank you, sir. Let
just
the
talk
record
to
reflect, Mr. Pizzi said
my
no objection
tenant.
to you making a
He's
comment.
gonna, just pretty quick, I talked to my tenant, he's gonna get in compliance.
Okay.
And if he wins, you want to put the banner back, that's okay, but this is between, so he committed to getting in compliance, so we can have the hearing. When we have the hearing, we're going to be in compliance. You know what I mean?
Okay.
Okay?
Thank you.
And you let me know, and, all right, thank you.
Thank you.
As your commissioner for District 3, I highly recommend you all start coming every month. This is just a show of what's going on in the town. Y'all need to come and be involved. Can't fix the problems on my own. I've been trying for 5 years. I'm the only commissioner up here working hard to fix this community. I highly recommend you all show up so we don't continue to have these problems with building code enforcement and everything else in our city. Can't change it unless it got community involvement. Please show up. I appreciate it. Every Tuesday, second Tuesday of every month, 7 p.m. right here. You get a speak.
Today is Wednesday. Today is Wednesday.
Sorry.
Today is Wednesday. Oh, I thought it was.
Madam Magistrate,
Yes.
if you're ready, I can call the next case. The other attorney and the last attorney on the docket is here. That is going to be, give me 1 second. Case number 5272. Counsel, please approach.
Thank you. Good morning, everyone. Good morning, Mr. Attorney, Madam Magistrate. This is Attorney Paul Arcia. I'm here on behalf of the owner who was cited. Not sure if I have to go here. I promise I won't be as long. I'm kind of tired after that. But with all, again, the owner just purchased the property. I have her title on July 25th. And she only learned about this condition after she purchased the property, but she's been very diligent in addressing it. There's a contractor that she's hired.
And Mr.
we're-
Garcia, if I may, I will interrupt you. It's 8.1 on your honor's docket.
Right.
Oh, I apologize.
It's here for confirming of the fine.
Correct.
Yes.
Martin Bellew and Rachel Bellew. I'm not I apologize if I'm mispronouncing the name.
You need this back?
Oh, thank you.
Here, Madam, if you could.
Thank you. Man, this is for 12 people. Okay. So yes, we were looking to see if we could have the fine mitigated based on the fact that this was not, she was not the person that caused the fine. She simply acquired the property after the fact. And as soon as she learned of the fine, she contacted myself and I asked her to hire a contractor. And the contractor is present here today and she has every intention to bring this property in compliance.
Okay.
And we would ask a certain period of time in which to submit the plans and in which to close the permits.
Okay. What's the town's position? Normally,
Well,
they
Madam Magistrate, I'm going to present the case.
Yes,
since I didn't
that's-
get a chance to.
yes, that's what normally happens.
Oh, I apologize. I haven't been up here before, so again, I apologize, madam. Thank you.
Chief Code Compliance Officer Jocelyn Ramirez for the Town of Pembroke Park, case 5272. Property owner Martin Beaulieu, Rachel Beaulieu, and Chantel Perret. Site address 311 Marine Drive, Pembroke Park, Florida. A notice of hearing to confirm fine was sent by certified mail July 24, 2024, posted to the property August 7, 2024, and posted to Town Hall August 9, 2024. The violations are for demolition of bathroom and kitchen done without permits. And it is not in compliance, therefore is the town's motion to confirm the fine of $52,050. And I have nothing further.
Thank you.
Okay. Now from the top, stating your name for the record and who you represent.
Certainly. John Arcia, and I represent Rachel Beaulieu and Martin Beaulieu, the owners of the property. And I just, if the magistrate would like to see, I do have a certificate of title that was issued to them on July 25th, 24th.
Yes, you may.
May I approach?
Yes, you may submit.
Oh, I think that's the original. Is that the original?
We won't be keeping this. Okay. For the record, council has just handed a certificate of title with an issue date of July 25th, 2024.
Which coincides with when the notice was sent out. And again, we're not, we understand that we take it as is, but we were completely unaware of this. And again, the new owner has immediately contacted myself and a contractor and is aware of the circumstances now and wishes to have the time to mitigate this. The contractor has explained that he can pull permits and submit whatever drawings are necessary in order to get this thing corrected.
Okay. I'm looking at the file. The original notice of violation was issued back in 2020. And whether or not the prior owner apprised your client, I don't know. Now, shy of 2 days approximately based on when the notice for the formal hearing was issued, but the fines have already accrued. And I'm sure you know, Counselor, but for the benefit of your client who's here, the purpose of this hearing is to confirm the fines, as you're aware, because.
Madam Magistrate, if I may?
Yes.
In conferring with the town, looking at the particular facts of this case, we are actually not going to object to a very brief continuance in this matter, being that it appears at face value that this actually qualifies for what Mr. Garcia can look into further is what is the town amnesty program. So when you have the residential units such as this, there are certain things that you need to do and get done in a certain time frame. We'd ask that you get that done in the next 30 days. Because otherwise this case will come back up and then at that point the fine will be subject to confirmation yet again.
I understand.
But once you're into the amnesty program, then at that point, it would kind of delay everything and then also qualify for a mitigation of up to, I want to get it right, was it 95%, 90%?
90%.
A 90% reduction. So right now you're currently incurring fines, but because of the situation, this would actually stop the fines, put you into the mitigation program, and then instead of confirming the fine today or fines continuing to grow, would stop at that particular point, which is why press upon you get that done sooner than later. And then you have that time frame, 6 months to a year, to get everything done. And then you would come back and have a mitigation of up to 90% under that particular program. But you have to apply for it. There is a deadline. That program is not always available. It's I want to say it ends in 2026, but don't quote me on that. But as far as it's being granted at the will of the city commission, of the town commission. So please do so. So with that, we'd have no objection. But again, otherwise, if this comes up and you don't apply for the program, and then at that point, our recommendation is more than likely to be to proceed.
And if I may speak, what you're saying
And if I can return your actual title to you, and normally we would keep this for the record, as we do for all evidence, but in this case, so we do need a copy of that, because you did submit that, but we're not going to keep the original. So
Okay.
Mr. Garcia, if you could send that to me, or we can make a copy real quick now. Or maybe just write copy on it as well. I don't want someone getting a copy of your title.
And for everyone's entertainment, I was about to jump over that, but I decided against it. Oh, I'm going to give it to the clerk to make a copy.
So Mr. Garcia, would you have any objection to that?
No, I don't. And what I was going to say is, I understand what you're saying, is just to clarify that if the fines are continuing to accrue, however, if we apply for the amnesty program, then the fines will stop and it'll give us time to correct.
And you got to agree to the terms and conditions of the program, as well as make the corrections.
And is that what City Hall, where would you, City Hall?
The building department, right next door.
Oh, thank you.
Yes.
All right, thank you. So
Town hall.
I make a motion.
Not a city.
I make a motion to continue this hearing, please.
For application into the amnesty program. By
Yes.
hearing no objection by the town, agreement of the parties, the motion is granted.
And when is the next hearing date now scheduled for this?
If your client enters the amnesty program, we will stop the case until corrected.
Okay.
So then you will move forward with mitigation at the time everything is corrected.
I will. Thank you very much.
No date.
Thank you again.
Great.
Thank you all.
Thank you.
Have a great
But
day.
otherwise, a new notice will be sent and mailed, so that's where you want to head that off.
All right, thank you again.
Thank you.
Bye-bye.
So we're going to need a continue.
Madam Magistrate, we would then go to the normal order of the
Okay,
docket.
they don't need anything, right?
Okay. Yes, we can, in the normal order from the top.
Is there any other attorney present? Okay, we will move forward in the order the people arrived.
Yes, that she's going to apply. So the minutes should reflect. Continue to apply for. Because the continuances are going to have a certain number of days. Because when she finishes, then we get straight to mitigation. Okay. No, thank you.
Madam Magistrate, we have 1, 2, 3, 4 cases for the same property owner for an abatement. So I'm going to read each one into the record. And then we also have one that it's new business. Okay, beginning with case 5378.
That's 9.1.
Yes, section 9.1.
Can I interrupt you for a minute, Jocelyn?
Yeah.
Can we do 5366? He's representing Mad Monkeys.
Okay, we will do 5366 on the property owner's manager requests.
That's 9.2. And all 4 of these cases are for the reduction of fine?
Yes.
Okay.
Okay, Chief Code Compliance Officer Jocelyn Ramirez for the Town of Pembroke Park, case 5366. Property owner Pembroke Park Warehouse Holding, site address 3152 West Pembroke Road, Pembroke Park, Florida. A notice of hearing to abate fine was sent by certified mail July 24, 2024, posted to the property August 7, 2024, posted to Town Hall August 9, 2024. It is the town's motion to reduce the fine of $102,157 by 85%. That amount is $15,457. That includes the recording lien fee, the release of lien fee, and the admin fee.
Hello. Good morning, close to afternoon. Thank you so much, everyone, for your patience. If you could kindly state your name for the record, who you are in relation to the subject property, and if the gentleman beside you could do the same.
Okay, my name is Nancy Romero. I'm the Senior Property Manager or General Manager for Pembroke Business Park. I'm representing the owner, and this is representing the tenant.
Hi, I'm Zahar Khamienko. I'm representing the tenant at Monkeys Events.
Okay, are you also a tenant? Or are you just representing the tenant?
He represents the tenant.
Okay. So we're here on the motion to abate the fine. The fine for this particular case were $102,157,000. The town has given abatement, which is 85%, which brings it to $15,457.
Okay, as much as I appreciate the discount or the reduction, I did want to say a few things. This case falls back prior to the tenant that was in there before, which caused all the violations inside the unit. With that being said, trying to correct all the violations, the permitting process, the loss of rent, et cetera, and also considering that we had COVID. I think this case is back from 2019. If we can ask for an additional reduction. To date, we have spent over $76,000 between attorneys and permit fees, violation fees, et cetera. So I am asking for an additional reduction, please.
What is that reduction amount?
At this point, I'll take anything. I mean, considering that we spent over close to $80,000.
And so what would the owner be looking for?
I would say hopefully like a $5,000 reduction.
What's the town's position with regards to a $5,000 reduction?
Town's position is 85% reduction.
I'll reduce the 15,000. Is it 15,000 to 57? 15,457 by $4,000.
Okay, thank you. So that would be in total $11,457.
Yes, please allow me to give oral pronouncement.
I'm sorry, say that again?
I'm going to give my oral ruling.
Oh, okay.
Does Officer Ramirez, do you have anything to?
No.
Okay. Based on the testimony and evidence presented, there is substantial and competent evidence to approve a request for abatement. The property is in compliance. Your fines are mitigated from $15,457 down to $11,457. That will include the administrative fee. You must pay the mitigated amount within 30 days, or the original fine amount will resume.
30 days.
Okay?
Okay.
Yeah, this is, 30 days.
You're gonna get a piece of paper now. You're gonna get a piece of paper now with all that amount. Okay. They might give it to us after I finish all four. So when I get it, I'll take you a copy.
Okay. No, thank you. Okay. Shall we go in the order and call 5378?
Sure.
Okay.
You can leave now.
He's going to get a copy of the order.
And did you include that if it's not paid within 30 days, it will revert back?
Yes. If it's not paid within 30 days, the entire amount will resume.
We have to pay it in here, right?
Yes.
Yes. You can mail a check or money order to the town of Pembroke Park, or you can bring it in person in the building department. Yep.
Good luck to you.
Ask you how to pay it later.
Yeah, I'll help you. Naslin, can I get a copy as well? Naslin, can I get a copy as well? Thank you.
The amount, you need the amount, Mary? Okay, you got it. All right, so we'll move forward with case 5378, which is on section 9.1. Chief Code Compliance Officer Jocelyn Ramirez for the town of Pembroke Park, case 5378. Property owner Pembroke Park Warehouse Holdings, site address 3182 Pembroke Road, Pembroke Park, Florida. A notice of hearing to abate fine was requested via email August 13. It is the town's motion to abate the fine of $1,600 by 85%, including the admin fee. That total is $325.
I'm okay with it.
Okay. Based on the testimony and evidence presented, there is substantial and competent evidence to approve a request for mitigation of fines. The property is in compliance. The fines are mitigated down to $325. This includes the administrative fee. You must pay the mitigated amount within 30 days, or the original fine amount will resume.
Okay.
And you'll get an order before you leave.
Okay. Next case on section 9.6, case 7447. Chief Code Compliance Officer Jocelyn Ramirez for the town of Pembroke Park, case 7447. Property owner Pembroke Park Warehouse Holdings, site address 330 Pembroke Road, Unit 440, Pembroke Park, Florida. A notice of hearing to abate fine was sent by certified mail July 23rd, 2024, posted to the property August 7, 2024, posted to Town Hall August 9, 2024. It is town's motion to abate the fine of $119,600 by 85%. This includes the admin fee. The total amount is $18,025.
Okay.
Again, I mean, I'm aware and I understand that ultimately we're responsible because we are the owner of the property. Unfortunately, most of these cases are caused because tenants don't listen to me. The current tenant that's in there, he did abide by all the rules and regulations, did get his BTR, but it was prior to his occupancy. Again, I'm asking, I appreciate the 85%, but anything additional will be appreciated. And again, I'm asking like another 5,000 reduction.
Officer Ramirez, what was the original amount, please?
That we're reducing to, or the
No,
entire amount?
the entire amount.
119,600.
And the town is offering $18,025 even.
Yes.
Your request for a further reduction is noted. I will give oral pronouncement unless either side has anything else to add.
No.
Based on the testimony and evidence presented, there is substantial and competent evidence to approve a request for abatement of the fines. The fines are mitigated. The town has offered $18,025. The respondent is requesting a further reduction. I will grant that further request and reduce the fine to $14,025. The administrative fee of $100 is included. This mitigated amount must be paid within 30 days, or the original fine amount will resume.
Okay, thank you.
And then the last case.
Well,
For
there's
today.
2 more cases. It's the last abatement.
The last abatement case.
Chief Code Compliance Officer Joseline Ramirez for the Town of Pembroke Park. Case 8756. Property owner Pembroke Park Warehouse Holdings, site address 3120 Southwest 19th Street, unit number 92 through 1160, Pembroke Park, Florida. A notice of hearing to abate fine was requested via email August 13, 2024. It is the town's motion to reduce the fine of $63,850 by 85%, including the admin fee, that's $9,663.
Again, another reduction would be nice and appreciate it. I would say an additional 3,000 reduction, please.
Your request for additional is noted. I'll give my oral pronouncement unless either side has anything to add.
No.
Okay. Based on the testimony and evidence presented, there is substantial and competent evidence to approve a request for abatement of fines. The property is in compliance. The fines are mitigated. The town has offered $9,663. The respondent has requested an additional reduction of the mitigated amount. That amount would be reduced to $8,663, which includes the administrative cost of $100. This mitigated amount must be paid within 30 days, or the original fine amount will resume. You have a question?
No, I was asking her about the 5th case.
Is there another case that you're here on?
Yes, but it's new business. It's not
Oh, okay. And Ms. Romero, you did hear that amount. I reduced
Yes,
it.
ma'am, yes, I agree, thank you.
$83.98.
Oops. We need whiteout. I messed this part up.
No, I can't.
Oh, he complied?
Right up.
He complied?
No.
Oh.
We talked about it. You told me you put it.
I meant to put the days right here. I don't like when my orders look like that. It's a long day.
I don't know, just.
Anybody else hungry? Okay. Okay, new business.
All right, next case is on section 7.2 on the agenda, case 8398. Chief Code Compliance Officer Jocelyn Ramirez for the Town of Pembroke Park, case 8398, property owner Pembroke Park Warehouse Holding, site address 3120 Pembroke Road, unit 430 through 431, Pembroke Park, Florida. A notice of violation was sent by regular mail, April 11, 2023. A notice of formal hearing with a copy of the notice of violation and affidavit of noncompliance was sent by certified mail, July 23, 2024. Posted to the property August 7, 2024. Posted to Town Hall August 9, 2024. The violations are for operating without a business tax receipt. I just recently spoke to the property manager. Apparently, that has been completed today, but I haven't had the chance to check it. But as of July 18, 2024, they were marked non-compliant. This is a repeat offense referencing case 7722, and that final order has been entered into the record. It is the town's motion to give 30 days, if not a per diem of $250, and a $100 admin fee.
Okay. Hello, Ms. Romero, if you could just state your name for the record as it relates to this case.
Again, I'm representing the ownership Pembroke Business Park. My name is Nancy Romero, and I'm Senior General Manager.
Okay. So you've heard the violations on the subject property. The town is offering 30 days to come into compliance or face a per diem daily fine of $250.
I understand.
Okay. The parties are in agreement. I'll give oral pronouncement. Based on the evidence and testimony presented, I find that there is substantial and competent evidence to support the town's civil violation notice. The respondent is ordered to come into compliance within 30 days or face a per diem daily fine of $250, which will accrue daily until the property is in compliance. The respondent is also assessed a $100 administrative fee for today's hearing. If nothing else, you'll get a copy of the order.
Thank you.
You're welcome. Okay. We can call the next case.
Next case is section 7.9 on the agenda, case 9723. Chief Code Compliance Officer Jocelyn Ramirez for the Town of Pembroke Park, case 9723. Property owner Numo Inc., site address 4444 West Hallandale Beach Boulevard, Pembroke Park, Florida. A notice violation was sent by regular mail June 7, 2024, and as well as to the email of the property owner. A notice of formal hearing with a copy of the notice violation and affidavit of noncompliance was sent by certified mail July 23rd, 2024. Posted to the property August 7, 2024. Posted to Town Hall August 9, 2024. The violations are for item 1. Property has more than one illuminated sign on the window. Illuminated signs are prohibited. Item number 2, prohibited flag banner sign on property. Item number 3, channel letter signs. Permit number 24362480 must pass all inspections. Item number 4, prohibited LED lights outlining the windows. Item number 5, operating without a business tax receipt or certificate of use. As of July 22, 2024, all the violations have not been corrected. Therefore, it's my recommendation. As well, I wanted to include that this is a repeat offense referencing case 5471. The final order has been entered into the record. And so therefore, it's the town's motion to for the property owner to fix this in 30 days, if not a per diem of $350 and a $100 admin fee.
And that repeat case number for the record was 5471?
9723 in section 7.9.
No, the repeat case number.
Oh, the repeat is 5471, yes.
Okay, thank you. Hello. Hi, can you please state your name for the record?
David Bugani.
And you're the record owner of the property?
Yes, ma'am.
Okay. Good afternoon, Mr. Bugani. Okay, so we're here on this case. You've heard the cities read the violations. You're being offered 30 days to bring the property in compliance and a $350 daily fine because it's a repeat offense, referencing the case number 5471. What's your position with regards to that?
This is the tenant, obviously. The only way recourse I had is to evict him, and which I did.
Okay.
I started the eviction, but it's gonna take more than 30 days because, the court,
Madam Magistrate, yes. I did speak to the property owner. He did mention he was going to do the eviction, and we did agree about 90 days because it's going to take him some time to remove the person.
Okay.
Apologies.
Is that something that can stay with the record? Do you need?
yeah, you can have it. I mean,
Thank you.
this is the eviction process, I guess.
This
basically.
says Respondent Exhibit 1. Okay, so by agreement of the parties, 90 days to come into compliance or a $350 per day fine. Okay, I'll give my oral pronouncement and you'll get an order. You're welcome. Based on the testimony and evidence presented, I find that there is substantial and competent evidence to support the notice of violation in town's position. The respondent is ordered to come into compliance within 90 days or face a $350 daily fine. This is a repeat offense. Repeat offense case number 5471. The respondent is also assessed $100 administrative costs for today's hearing. And I also want to add for the record that the $350 per day daily fine will continue to accrue until such time as the property is in compliance. I moved the line there and I struck through there, so. And we keep a copy of this for the file. Oh, okay. We can call the next case.
Next case is on section 8.3 of the agenda, case 5557. Chief Code Compliance Officer Jocelyn Ramirez for the Town of Pembroke Park, case 557, property owner Gisela Algarin and Daisy Lorenz Valle. Site address 241 Susan Lane, Pembroke Park, Florida. A notice of formal hearing to confirm fine was sent by certified mail July 24, 2024. Posted to the property August 7, 2024. Posted to Town Hall August 9, 2024. It is the town's motion to confirm the fine of $32,300.
Hello, good afternoon. Can you please state your name for the record and who you are in relation to this?
Okay, my name is William Lopez. I just bought that property like a few months ago. She told me everything was clear with the town. I realized that's not really the truth. So I don't know what I'm going to do or what I have to do.
Well, for today's hearing, excuse me, we're here to confirm the fine. You had fines running on your property because it didn't come into compliance. In order to have the fine stop and you have to be in compliance. So
What basically is wrong in the property?
well, you can, with the notice that you received, you'll need to go to the building department, and they'll sit with you to tell you what you need to apply for and bring so that whatever permits that you need to make the corrections, you can do that.
What permits I need?
This is not the building department.
Okay.
You'll have to go, so when this hearing is over, go inside and ask to speak to someone from the building department. But for today, the fines that we're running, because the final order was issued a little while ago, and so those fines have been running daily, and now you're at the amount of $31,950.
31,000?
Yes.
Oh my God.
Madam Magistrate, if I may?
Yes. I'm sorry, it's 32,000.
If you
With
just
the
recently
admin.
purchased the property, did you do a title transfer?
Yeah, I went there and they told, and I applied for the,
The DMV and
yeah.
for the title
And they
transfer?
tell me, and she brought the papers, whatever she has, she said everything is complete, but that's the reason why I paid the property.
So it seems like you are eligible for the amnesty program, but you have to bring that proof of title that you are the owner of that home.
No, I have the title, but
Your name?
I don't even have my name right now because like 2 months ago, I have like a hard situation.
Okay.
I just went to the hospital. I just came out from the hospital and.
Okay, that is understandable. I'm just learning about this that he recently purchased, but again, he would need the proof of that, and he can enter the amnesty program.
Mr. Lopez, and I hope you're doing much better.
Oh my God.
I'm glad to see that you are here. With regards to the title, are you able to get the title in your name? You're going to need that in order to participate in that program.
Okay, so
So,
I have to get the title of my name. Now, okay. So I gotta go to Department of Motor Vehicles.
Department of Highway Safety Motor Vehicles, yes.
So I have to go to the building department and find out to get that, or what is the steps I gotta go through?
The first step is making sure you have the proof of ownership, that you are the owner of the mobile home, so you need the title under your name.
So I have to put the title of my name and then come down here.
Yes, because you're saying you recently purchased the mobile home, so now you need to give proof that you are the property owner.
Okay.
Okay? And then once you have that proof, and also your driver's license has to match that address too, that is your primary resident. That way you can enter an amnesty program and the fine will stop. And you
Okay.
can, and you have
So I
time to
gotta put it on my name and then come down here again?
Yes.
But your driver's license or state issued ID has to have that address showing that that's where you live.
Okay.
Okay? So do we want to just continue this for 30 days?
Yes, we can continue it for 30 days.
Or maybe you can give me more time because tell me, I spent till the last penny to buy that property and I have a hard situation. Now basically I'm out of work. So I'm going through really,
Well, so we're giving you 30 days so that you can get the title in your name and you can update your license or your ID with your address.
okay.
So I don't know what the Department of Motor Vehicle charges for that, but that's something that should be reasonable.
Yeah.
That you should be able to afford to pay, because you need those two pieces of documents with your name and address.
But the driver license and
The title. So
Title.
you bought the property, your mobile home from someone.
Yes.
So you should have a piece of paper that shows you're the owner for you to go to Department of Motor Vehicle to have them issue a title.
Okay.
Okay, they'll register the mobile home.
Because
as
I
you-
know that's like a regular when you apply for a regular title for the automobile, just something like that. How long they take before when I apply or when
I don't know the answer to those questions, but they have, if you can, today or sometime this week, go there or make an appointment. But you need to do so quickly because 30 days will go by fast.
No, I know.
Yeah.
That's the way you can give me a little bit more time, so that's why I can try to get all those documents. Right?
If this case has to come before you, it will have to be 60 days. So it doesn't matter which magistrate.
You can give me more time, maybe 60, 90 days, so that's what I can get all that.
Does the town have an
Okay.
objection for 45 days?
I would say a continuance would be 60 days. That way it would be aligned with the magistrate date.
60.
Okay, so, but understand, so either one of two things are going to happen. Either you're going to have, if you have the documents before 60 days, which I encourage you to get them, because you can then go and apply to the program, and so you won't come back here. But at the 60-day, in 2 months, if you come back and you're not enrolled in the program, and you don't have the documents to show, remember, we're here today to confirm the fines.
Okay.
You've got to act quickly. And the other thing that you should know, the fines are still accruing. So that's exactly the amount that's here today. It's going to be higher unless and until you get in the program or the property comes into compliance.
Okay.
Okay?
Thank you, Your Honor.
Okay, so 60 days.
60 days. You want to give me paper, something like that? Or?
Yes.
And Madam Magistrate, if I may, can you ask the respondent if they have an objection to, now that they're the owner of the property, and is that confirmed? So we can change the name of the case?
That's not confirmed.
Okay.
And that's why I told him, like, if the case is back up in 60 days, we're proceeding with confirming because.
Right.
I just wanted to, again, just the title, the name of the case, to make sure that he has proper notice, but on the record, he has proper notice of this upcoming hearing.
Reflects that certified mail and posting in accordance with the 162 until such time as that information is updated accordingly. The evidence demonstrates that notice is properly noted in accordance with the law. He's here, so it
Understood.
I think the rest speaks for itself, and based on his testimony as to his ownership. So.
Go slowly because my English is not too good. And
So this is
now
all for
I'm a little
purposes.
bit nervous and I understand it's getting low.
This is for purposes of the record. So, in other words, you said you're now the owner. You have to show proof, right? And that's for you to get in the program, because otherwise, when the case comes back, if you're not in the program, the fines are going to be confirmed. The town's going to look to have the fines confirmed. Okay?
You're going to give me any papers?
You're going to get.
He's going to get a continuance in the mail
Oh, that's right,
Yep.
because there was a change.
You'll have to get your notice in the mail, but 60 days. Do we have a date? It'll be October what?
16.
October 16th.
October 16.
But you'll get something in the mail, but write that date down,
Okay.
okay?
October 16. Thank you so much.
You're welcome. Good luck to
Have a
you.
wonderful day.
You as well.
Okay, bye-bye.
You know, I feel bad for the people, but when we're done, you know, we'll take a break, yeah. We can call the next case. Jean left us. Yes. I didn't want to drink, so I don't. I'm so thirsty.
Next case is on section 7.6 on the agenda, case 8526. Chief Code Compliance Officer Joseline Ramirez for the Town of Pembroke Park, case 8526. Property owner MAYRA RUIZ de Villa and ALBERTO GUEVARA. Site address 3100 West Hollandale Beach Boulevard, unit number 106, Pembroke Park, Florida. A notice violation was sent by regular mail, May 12, 2023.
Hello.
A
Aquí
notice
estoy,
of
Line.
formal hearing with the copy of the notice of violation was sent by certified mail, July 19, 2024, posted to the property August 7, 2024, posted to Town Hall August 9, 2024. The violation is for an installation of shed without a permit As of July 18, 2024, there hasn't been any compliance. Therefore, it is the town's property owner 60 days to correct the violation, if not a per diem fine of $100 and a $100 admin fee.
Good afternoon. If you could please state your name and who you are in relation to the property.
Tu nombre y tu relación sobre la propiedad. Mi nombre es Mayra Ruiz de Villa. La propiedad, propietarios somos. Traduce, Line.
Her name is Mayra Ruiz de Villa. She is the property owner.
Arbi.
Before we go any further, let the record reflect the respondent is holding a cell phone with someone on speaker. The person on the other end, who are you?
I am her sister's daughter-in-law.
Okay.
My name is Lynette Barreras.
Okay, and she's using you to translate. There is a gentleman next to her, so I'm guessing he doesn't understand English. Is there an objection from the town for this form of translation? Of course, it would be subject to the person on the other line being sworn to translate accurately from English to Spanish and Spanish to English. Is there an objection, or?
I have no objection unless the town attorney has something to say about it.
Obviously, the issues are apparent with allowing testimony virtually over a phone, especially when it's sworn testimony and it's sworn interpretation. There is a legal risk given the testimony and the interpretation. However, defer to Madam Magistrate your sound discretion.
Dime, Line, ¿qué dice él?
Is there anyone? A member of the audience who speaks Spanish who could? Okay.
¿Qué dijo, Line?
Porque están teniendo un problema que dice que hay
And what time did you arrive today? Were you here before? Okay. Thank you for your patience. And so you were.
Oh, gracias.
Okay.
Gracias, me va a traducir. Sí. Está bien, gracias, Line, mija.
Dale, besito.
Bye.
I just need you to raise your right hand so you can swear that you swear and affirm that your translation from Spanish to English and English to Spanish will be the truth and accurate, and you understand both languages.
I will.
Okay, thank you. And for the record, tell me your name, who's serving as a translator for.
My name is Luis Quiñones.
Okay, thank you, Mr. Quiñones. Okay, I was asking for the respondent to state her name for the record and confirm whether she's the owner of the property.
Su nombre completo y que usted es la dueña de la propiedad.
Mayra Ruiz de Villa. Y el dueño y dueño.
¿Y usted es el dueño también?
Sí.
Sí. They both owner of the property.
Okay, so if you could tell her that her property's been cited because there was an installation of a shed without a permit. And so the town is offering to give her 60 days to apply for a permit to get the property in compliance, or she will face a $100 daily fine.
Okay. La ciudad la está porque montaron una casita sin el permiso, pero entonces necesitan el permiso de la ciudad, que son ellos. Cuando termines aquí, vas allá, que la muchacha que está ahí, ella te va a orientar para que saquen los permisos para montar la casita, para que si no tienes una multa de $1,000 en 60 días. Tienes que venir y ellos ahí en el building, en el edificio, ellos te van a dar los requisitos que necesitas para la construcción de la casita. Y mientras tanto, tienes 60 días para resolver ese problema. Si no,
But I need to know, what's her position? The city's offering 60 days or a $100 daily fine if she doesn't come into compliance.
Okay, ellos te están dando 60 días o $100 por cada día, que no de eso. ¿Qué quieres hacer? Si quieres con los 60 días, para que puedan hacer para resolver el permiso. 60 días. Okay, the 60 days, okay. Yeah.
Okay. I'm going to provide the oral pronouncement. Based on the evidence and testimony presented, I find that there is substantial and competent evidence to support the violation issued by the town. The respondent is ordered to come into compliance in 60 days or face a $100 a day daily fine that will continue to accrue until the property is in compliance. The respondent is also assessed $100 for administrative costs for today's hearing.
Okay, so eso tiene los 60 días. Si no, yo la voy a multar por cada día adicional.
She'll get a copy of the order.
So, ellos te van a dar una copia.
Quisiera decirle
Ajá.
a ella que
El dueño
del parque
Okay.
no autorizó
Sí.
hace años y tanto ella en poner la casita.
Está bien, no, pero es lo mismo, es mi problema, es lo mismo igual.
What is he
También.
saying?
Okay, he's saying that the manager of the park, that she say that they don't have no problem with the shell because he got the measures and everything, but I'm telling them they
Right, but this is a violation of the city code.
Ya, es la ciudad la que te está, es lo mismo.
Y ese tipo de casa está permitida.
Bueno, and he say, he asked if that shell is the one permitted by the city or not. If not, they throw it down.
Oh, so he wants to know, can he get a permit?
Yeah.
Officer Ramirez, is this, will he be able to legalize this? Is the
That would be
question.
up to the building department.
Yeah.
I mean,
So when he goes to apply for the permit,
Okay.
the building department is going to, because they're the ones that issue permits.
Okay. So, no, cuando vayas a orientarte en la ciudad, aquí, ellos son los que te van a decir si está permitida o no por la ciudad. Porque el parque es una cosa y la ciudad es otra.
Because compliance,
Ya yo llevo casi 2 años
Okay.
en el litigio.
and if you could tell them compliance is 2 ways. He gets a permit that approves the shed or removing the
Remove
shed.
the shell. Okay. Okay. Son dos cosas. Si ellos te dicen que no, la tienes que remover, como quiera tienes que tener un permiso para quitarla. No la puedes quitar sin permiso. Igual si para dejarla, también necesitas el permiso. Eso necesitas venir. Ahora mismo no. Yo te aconsejo ahorita, vas aquí atrás, que es ella misma la que se sienta. Allá en esto, y que ella te diga lo que necesitas. Todo lo que
Okay.
necesitas.
Good luck to you. And yes, thank you. And I'm sorry
Mira,
it
recuerda
took
que
long.
60 días para eso, pero si ahorita lo haces, vas ahí al building ahí y todo eso. Okay.
Está bien,
Sí.
muchísimas
Okay.
gracias.
A orden.
Que pase buen
Okay.
día.
Thank you.
Thank you so much. Okay. It's been a while since we've had such a long hearing. Almost forgot what it felt like. But I do thank everybody's patience.
Buenas tardes a todos.
Yes, buenas tardes. Did they sign up? I don't think they signed. Maybe we can put a sign on the door in English and Spanish for people who come late.
what do you want me to do?
No, so that they can sign their names on this. Oh, you did?
already signed everything.
Oh.
That's the second page.
Oh, okay. Whenever you're ready.
Okay. Next case is on section 7.5, case 8441. Chief Code Compliance Officer Jocelyn Ramirez for the town of Pembroke Park, case 8441. Property owner Luis Quiñones. Site address 3140 West Hallandale Beach Boulevard, Lot 17, Pembroke Park, Florida. Notice of violation was sent by regular mail, April 28, 2023. A notice of formal hearing with a copy of the notice of violation and an affidavit of noncompliance were sent by certified mail, July 19, 2024. Posted to the property August 7, 2024. Posted to Town Hall August 9, 2024. The violations are item number 1, installation new wooden fence without a permit. Item number 2, installation of shed without a permit. Item number 3, installation of a screen room without a permit. Item number 4, installation of electrical cameras without a permit. As of July 19, the property is not compliant, and it is the town's motion to give the property owner 90 days to correct all violations, if not a per diem of $100 and a $100 admin fee.
Hello, Mr. Quinones. If you could state your name for the record and who you are in relation to the subject property.
Yeah, hi, I'm Luis Quiñones. I'm the owner of the property.
Okay. So you've heard the violations listed, and the town is offering 90 days to correct and comply with everything, or face $100 a day.
Okay, I will. Yeah, I already came to the building and
Okay.
I'll talk to her. She gave me the orientation, so I'm working on it to fix everything. Yeah, the fence already took it down, so I could do it the right way. So
Okay.
yeah,
Perfect.
appreciate
So
it. I'm
make sure
sorry for don't be before here because I didn't know the notes, but now I'm here, so I'll thank you.
And I thank you for being here. Just make sure you stay in contact with the town and Officer Ramirez so that you can come into compliance.
I will.
Based on the evidence and testimony presented, I find there is substantial and competent evidence to support the violation notice. The respondent is ordered to come into compliance within 90 days or face a $100 per day daily fine, which will continue to accrue until such time as the property is in compliance. The respondent is also assessed $100 administrative costs for today's hearing. Good luck to you. You get a copy of your order.
Okay.
And again, thank you so much. Our hearings normally aren't
Yeah, I was
this
such a-
long, but we do want everyone to have an opportunity to be heard.
Okay.
Thank you. Okay. Next case when you're ready, Officer Ramirez.
Next case on section 7.3 of the agenda, case 8403. Chief Code Compliance Officer Jocelyn Ramirez for the Town of Pembroke Park, case 8403. Property owner Timely Property, Inc. Site address 3001 West Hollandale Boulevard, unit number 313, Pembroke Park, Florida. A notice violation was sent by regular mail, April 11, 2023. Notice of formal hearing with a copy of the notice violation. An affidavit of noncompliance was sent by certified mail, July 19, 2024. Posted to the property August 7, 2024. Posted to Town Hall August 9, 2024. The violations are for SARS Apartments operating without a business tax receipt or certificate of use. As of July 18, 2024, the property is non-compliant. Therefore, it's the town's motion to give 30 days to comply, if not a $250 per diem and a $100 admin fee.
Good afternoon, everyone. And
Good afternoon. Again, thank you for your patience. If you could
Good.
please state your name for the record and who you are in relation to the subject property.
okay, my name is Wilhelmina Johnson, and I'm the controller accountant for SAR Apartment Capital. So I'm representing the tenant. The owner, Abio Palacios, is out of town. I wanted to make a note that I did come yesterday with the application for the inspection and the business license.
God bless you.
So we are requesting time, the 30 days for, I forgot your name, Ms. Nasley? Yeah, nurse, to process the application for us.
Okay. And you're here you have authority to speak?
Yes.
On the matter okay.
Yes. As the tenant, not the owner of Timely. Because I think the notice had Timely Property, but I'm here as the tenant, SAR Apartment Capital.
Has there been any contact with the owner of the property?
No, there has not been no contact from the property owner.
Yeah, I work hybrid as the accountant, so I'm only there 2 days a week. And the day you actually came, I was on vacation. I saw July 18. So I'm coming as the tenant, but the owner just told me fill the paperwork out. They submitted the floor plan for me. They notarized the paperwork, and so I brought it yesterday and submitted it.
Okay, so the owner has filled out his portion.
Yes, yes,
Okay.
You mean the business owner, right?
yes.
Okay.
Not the owner of the property.
No, the owner of the property, because it's two applications. The inspection one has, like, I guess the fire stuff, but the owner actually filled out, like, she gave me the floor plan. She filled out the second part of the inspection report.
And she signed that?
It was notarized by them, yes.
Oh, okay,
Yes.
okay. I'm satisfied. Is the town satisfied? Because with commercial uses, you've got the owner who owns the property, you've got the commercial tenant, and oftentimes in various cities, certain authorization, documented authorization has to be provided by the owner in order for tenants to procure certain permits, BTRs, et cetera. And so that signature I find to be representative of the owner's knowledge of the violation. So my question is, how does the town want to proceed? Are you okay with Ms. Johnson making the request?
You requested 30 days, right?
Yeah, I wasn't sure what was going on. Like I said, I was on
I mean,
vacation.
I suggested 30 days, so.
Okay.
Because it depends on how long is it going to take you to process. Because like I said, I did my part yesterday. I submitted both documents. There's the business license application and the inspection application where I guess the fire department comes in and does their inspection or whatever. So
If I may speak, it not only depends on me or zoning, depends on you as well, because you need to pass the inspection. So, like I said, this week, by the end of this week, we're gonna send your application to zoning, and then we should wait until the inspections, which you have to pass them, okay? And then you're gonna be able to pay for the certificate. So it's a process. It's not a long process. As long as you have everything okay, it's gonna be fast.
okay. So then I guess back to you. Is it 30 days or is it longer? I don't know.
We can't guarantee how long, but the thing is that this has been written since April 11, 2023. We're here in 2020, more than a year. I don't know.
I just started working here in February, so I didn't know what was going
I
on.
understand, it's not your fault,
Yeah.
but 30 days is the recommendation.
But, and let me just clarify for the benefit of Ms. Johnson, the town is seeking to have a final order issued with 30 days to comply. And so you're representing the tenant requesting, for more time. But just so you're clear, you're not here representing the owner.
So you make a good point. So should the owner have been here today? Because I came as the tenant because they told me I needed to fill.
The owner should have been here.
Okay.
That's why I asked you, are you here speaking for the owner with his or her permission? And you clarified it's for the tenant. So,
Yeah, because my boss is Abio and he's the one who signed, but I'm the controller that, occupies the unit 2 days a week. So I filled out the application. I'm representing Abio. But Timely is the owner of the building. So if they were supposed to be here, I didn't know. They just told me, Mimi, well, my nickname is Mimi, fill the application and just bring it to them. So I'm just here as the tenant.
I understand. So you already presented your testimony. I do want to add for the record, is anyone here representing Timely Property, Inc., seeing or hearing no one come forward? With that said, does anybody else have anything else to add? I'll give oral pronouncement.
No.
Okay. Based on the evidence and testimony presented, I find there is substantial and competent evidence to support the notice of violation issued by the town. The respondent has been duly noticed. The record does reflect that the representative for the tenant is here, but is not here on behalf of the owner. The owner is, or the respondent is, ordered to come into compliance within 30 days or face a per diem fine. Officer Ramirez, what was that per diem fine again?
$250.
Or face a $250 per diem daily fine, which will continue to accrue daily until the property is in compliance. The respondent is also assessed $100 administrative cost for today's hearing.
Okay.
$250. So
So if we're not in compliance in 30 days, then we're going to be assessed the fine.
if the owner of the property
yes.
is not in compliance.
Okay, okay.
He or they or she will be, the fines will start to accrue.
Okay.
So you're gonna have to mail it. Also, 250. Okay. Nazi, let me see that order again. No, first page. No, that's wrong. Mm-mm. It's no. No, she's not she's not the respondent or the representative for the respondent, so no, okay? Mm-hmm. You're welcome. Okay. Well, you'll stay in contact with the town. If you want a copy of the order, you can have, you can obtain one.
I'll wait for the copy.
Yeah.
No problem. Thank you so
And
much.
thank you so much for your patience.
No problem. Thank you.
No, you're next.
I'm next.
We can call the next case when you're ready.
Next case on section 10.2 of the agenda, case 9501, Chief Code Compliance Officer Jocelyn Ramirez for the town of Pembroke Park, case 9501, property Yasim 5401 LLC, site address 5401 Southwest 25th Court, Pembroke Park, Florida. A notice of hearing to extend time requested by the owner was sent by certified mail July 23rd, 2024, posted to the property August 7, 2024, posted to Town Hall August 9, 2024. The property is still not in compliance since the tenant does not have a BTR. So it is the town's motion. This is already the second and final extension, so it will be 30 days. If not, a per diem fine of $500 since it's a repeat offense, and a $100 admin fee.
Hello, good afternoon. Thank you for your patience. Can you please state your name for the record and who you are in relation to the property?
Okay, my name is Roger Mimoun, manager of Yasim West 5401 LLC.
And you're the managing owner of...
I am owner. Yeah.
Okay.
I am owner, sir.
So this is here for an extension. The town is granting a fine 30 days or to come into compliance. If you're not in compliance, a $500 per day daily fine will begin.
Why me 500 and the other people $100? I don't understand.
Well, this is a repeat violation. It's a repeat
What repeat
offense.
violation? The permit?
No, Mr. Roger, the hearing before us is asking for an extension.
An extension, I understand.
Yes. So if you're asking for an extension, you have some history with the case. So asking the question of what is the violation for, that's not this hearing.
No.
And the building department is next door. You can speak to one of the inspectors.
Okay. All right.
Okay?
No problem.
Because here we're just talking about whether,
I understand.
more time.
I don't know. This is a repeat violation? To get a business permit?
Yes, this is a repeat offense since you had other tenants who did not obtain their BTR. And so this is moved
Okay.
forward.
I understand that. Okay.
Yeah.
Okay.
I understand.
Okay, anything?
She's right.
Oh, okay. Anything else you'd like to add before I give?
We applied for the permit, right, already. and to pull a permit for the electrical. This is the only problem I have, right? My duty is to get the permit to electrical and comply with for all the exit lights. They were all out of order, so you already done it. Okay, and this coming Friday, I spoke to Jeffrey. He's going to send the electrical inspector to inspect the place, and that's it.
Okay. And
This is the only thing I'm responsible, right?
well, we're here for the extension. Again, when you go
I
to the,
understand. Okay.
yes, and they'll be able to sit with you and answer all of those questions.
Okay, no problem.
Okay. Based on the testimony and evidence presented, there is substantial and competent evidence to approve a last and final extension of time. The respondent is hereby ordered to come into compliance within 30 days.
90 days.
30 days.
Give me 30 days now? You told me 90 days.
30 days, the property right now is in disrepair. There hasn't been no effort to clean up. Your tenant hasn't really moved forward with anything.
Oh, you're talking about something new now.
No, I'm talking about your tenant who's occupying the space without a BTR, a business tax receipt, and has not done, still is doing illegal work. So he needs to clarify all that in 30 days.
Okay. How about what's out the 90 days that you're supposed to get?
This has been ongoing since April 5th, 2024.
Okay.
This is the second extension that we're giving.
I believe this, the.
So what, I have two extensions, 90 days and 30 days?
No, you just have a 30-day extension.
That's it.
Yes, that's what I said at the beginning, Mr. Roger, 30,
no problem.
last and final extension. So from the top, based on the testimony and evidence presented, there is substantial and competent evidence to approve the request for a last and final extension. You are ordered to come into compliance within 30 days. Failure to come into compliance will result in a $500 per day daily fine, as this is a repeat offense. Those fines will continue to accrue until such time as the property is in compliance. You are assessed $100 administrative cost for today's hearing.
What my problem is, I don't understand now. I had a violation because of the exit light, because the tenant pulled a permit for business permit. So they told him you have to fix the exit light. And that's it. For the other violation, I have no idea what it is.
This
Now I
case,
just hear it.
Mr. Roger, and maybe you want to write this down if you haven't already, but you should have this paperwork because it was provided. Case number 9501. That is the case that we're on. That is the extension request for that case.
Okay.
Okay? You're going to get a copy of the
I
order.
understand. I'll speak to you. You explain to me.
And thank you for your patience. Thank you for your patience.
Nasli is going to give you a copy of the order.
So, you're the first time seeing you smiling. The whole time you're very serious. Thank you very much.
Good luck to you.
Have a good day, sir. Madam Administrator, may I call the next case?
Yes.
8.5 of your docket, the last sign-in case we have, case 7003, Polino Kanya. Is that it? Sir, is that you?
What case are you here for?
5304.
He didn't sign in?
He already signed. I have it here.
Oh,
so.
okay. 5304.
Okay. Well, then someone signed in and left. So we'll put that back on. Put that on recall.
5304.
And that would be case number 8.2, 5304, Gary Pigot.
Yeah.
Okay.
So,
3407 Southwest 52 Avenue, Pembroke Park.
Miss-
Hearing to confirm fine.
Okay. Mr. Gary Pagat, I don't recall whether you were sworn in, but can you please raise your right hand?
Yeah, I was here at 9.
You,
Yeah.
okay, very good.
Right.
You swear and affirm your testimony you provide will be the truth, the whole truth, nothing but the truth? Yes, ma'am. Okay, come on forward to the lectern.
Okay, I will present the case and then you may speak on the matter. Chief Code Compliance Officer Jocelyn Ramirez for the Town of Pembroke Park, case 5304, property owner Gary Pigot, site address 3407 Southwest 52nd Avenue, Pembroke Park, Florida. A notice of hearing to confirm fine was sent by certified mail July 24, 2024, posted to the property August 7, 2024, posted to Town Hall August 9, 2024. It is the town's motion to confirm the fine of $48,900, and the property is still not in compliance. As of July 24, 2024.
Hello, Mr. Gary. If you could state your name for the record and confirm that you are the owner of the property.
Gary Piggott, I'm the owner.
Okay. So we are here to confirm the fine. It appears that the violation still exists and your fines have accrued to a dollar amount of $48,900 and they're still accruing.
What I would like to do is first state the fence is a complete disaster because of the original contractor who I paid, and he told me he pulled the permit. I think I came here maybe about a year and a half ago, and I remember saying I had another contractor who's going to person, and because I didn't get any feedback, I thought he actually did the permit and everything was done. So when I got this notice, I was like, holy crap. So I contacted another contractor, and they got the paperwork from me last week, and they're supposed to come and pull the permit for that. I take full responsibility for the negligence because honestly, I thought it was a done deal. Bottom line is, I know I'm in a situation where I have to get this done within 30 days, or it may be even 10, because they confirmed to me they'll be coming here this week to do such paperwork. So that's where I am regarding the fence. The exterior roof, I have actually communication on this because I'm at the corner lot of my complex, and there's a tree that's there in Holly Ridge Apartments that's impacting all the growth on my, porch, outside porch. And that's also bleeding the sap onto my roof, which is what's creating this. So I contacted USA Services, who's our management company, and they reached out with a letter to Holly Ridge manager to prune the tree and to pressure wash or clean my roof and my porch. This is the fourth time since I've been living here for over 20 years that I have to deal with this expense on my own. But this time I figured I need to get Holly Ridge apartment complex to be responsible for that. So that letter was sent off. I need to contact USA Services to find out what's the status. But I understand I have to do it to avoid further fines. But I just wanted to share the, I don't want to say the logic, but the reality of what's happening at my unit where I am located at a corner lot and a tree that cannot be pruned per Florida statute. Or, sorry, not pruned, but actually removed. So that's the condition that I'm in. From a fine standpoint, I would ask for at least $500 and 30 days to get this thing done.
Your fines are accruing. They've been accruing. This hearing is to confirm the amount that was stated in the town's presentation, and that's $48,900. So fines have been accruing for quite some time. Actually, this has been going since probably a little bit before the violation was issued, but I'll use that date. August 3rd, 2020 is when the notice of violation, your final order wasn't issued until 2021. And so the fines have been running for a little bit, Mr. Gary. And so today's hearing is to confirm that amount. It's good that you're making diligent efforts to get this underway with regards to the fence and the condition you note and the exterior of the roof. And likewise, the balcony exterior, the maintenance required there. But the town is seeking to confirm that. So what that means, this amount will be confirmed, but the fines do still continue to accrue until the property is in compliance. You're taking diligent steps and not waiting for your neighboring property to kind of help you ameliorate the situation. Once everything is complied with, you then can make application for mitigation or reduction of the fines. And some of what you stated in your testimony, you could include as a part of why you're requesting the mitigation, whatever circumstances that warrant that. But for today, it's for confirming the fine. So the request for 500, maybe you're thinking this is mitigation. We're not there yet, compliance.
Okay, understood.
Okay.
Well, I confirm the amount that was just shared, and I will execute the corrections.
Okay, and if you please stay in contact with the officer. If there's nothing else, I'll give my oral pronouncement. Based on the testimony and evidence presented, there is substantial and competent evidence to support the town's position to confirm the fines. The testimony and evidence reflect that the property is still not in compliance. The fines are hereby confirmed. The confirmed amount is $48,900. That amount will continue to accrue at the daily rate it's been accruing. You are ordered to comply and correct the violation. You are also assessed $100 administrative cost for today's hearing. Good luck to you.
That's it?
Yes, Nasli will give you a copy of the order. But as soon as you can get that permit closed and the exterior maintenance done, just please call me. I'll do a reinspection. I'll be happy to stop the fine and move forward with mitigation.
Understood. Thank you.
Thank you.
Because your fines are accruing at $100 a day, just so you're aware. It's in the order. Okay, good luck to you. And thank you so much for your patience.
All right, thanks.
Ms. McKinney, that concludes your in-person docket. There's no one left in the room. We've gone through the entire sign-in sheet. There are, I see 5 cases remaining for your no-show docket.
We can call them, or unless
Yeah, we're gonna call them, but we'll take a little break.
I was gonna suggest.
If you wanted to take a break, yeah.
I did not drink any water.
I drank.
All right.
Although I should have, because my voice was kind of.
All right. So, Madam Magistrate, are we on recess for 5 minutes?
5 minutes is better.
All right. You have to. You're the one who says we're on recess.
So we're taking a break?
5-minute recess off the record.
5? All right. I don't have the option to stop the video right now, so we're still on live, only for you guys now.
No, not the video, meaning there's no one before us, no one speaking.
All right.
We're on a brief 5-minute remission. Oh, yes, yes. Continue to record. We're still in session. I do feel like stretching my legs, though.
This meeting said forever.
My legs, my back, my
I got a 1 o'clock that I'm not going to make now.
Oh my gosh. You know what? Maybe I should go to the ladies' room just in case. You never know. I drink a little bit of juice because I had a banana. it's freezing in here. It was quite. When I arrived, I was like, yeah, it feels so good. It was so hot outside.
Oh, I'm freezing.
I know, when it was hot.
Yeah.
Earlier, right?
With the windows, I can't even tell if it's
Yeah, it looks a little overcast.
overcast. I can't even tell. We all ready?
I'm ready.
It's freezing.
Can we proceed, or do you wait for?
Oh, we can proceed. I do want to bring to the town's attention, I don't recall the case number offhand, but the case in which where Attorney Dawson representing the tenant, that case, we did not hear that case, so we do need to hear that.
What do you mean we didn't hear the case?
I didn't enter oral pronouncement.
For 9150?
That's the one, the gentleman that we confirmed that he was here previously. The attorney wanted a continuance of the matter. She indicated she did not represent Attorney Dawson, for the record, did not represent the owner of the property. So I did not take testimony. There was no presentation on the case. And I believe that matter was on for confirming the fine.
I believe you did.
I thought you did.
You did.
Did I?
We wouldn't have
Well,
passed the
wait,
case
did
without.
you complete the order?
I don't believe Nasli completed the order.
Okay. We'll just hear it again for the record, and we'll confirm the.
But we'll ask her. We'll ask her, because now it's been a long day. So, guys, I do apologize.
I believe you did, because you did mention, again, we can go back and take a look, but I believe you did. As far as at the end of that particular case, you made your ruling. You talked about the owner. I interjected, provided some historical information on the particular case, and move forward with the pronouncement.
Okay.
So we can, what we'll do is let's proceed with 7.1, and then we can take a brief recess and we can go back and take a look.
Yeah, if Nasli has the order filled out, that's confirmation for sure of the oral pronouncement.
But we're happy to confirm.
Yeah. Okay, 7.1. Oh,
Okay.
they're still on. Yeah. Is it technically 5 minutes? I don't know.
I don't know. 7.1, 7.4 are both timely property. That, as the owner, that goes into the young lady who was here on the other case. Was it 7.3?
Ms. Johnson?
Right, because she was only here on behalf of the tenant.
Right.
I paid attention to that. Is it?
But we'll state that on the record. It's important to ensure that when you have a commercial tenant representative, to confirm if they are if they're here to speak on behalf of the owner, because otherwise, it's just best that everyone is clear.
Nasli, just Ms. McKinney had a question on case 9150. That's the one with the noise violation. Miss Angela Jocelyn was here.
Remember the attorney?
It was the second case that we heard.
Attorney Dawson.
That she made an oral pronouncement. We believe she did, but she'd just like to confirm on the record. Or confirm the record.
91. No, but you didn't confirm the.
Right. I did so in the case that Johnson was there, but with regards to that, and the reason, just so you understand, there were so many more people here. We needed to address the respondents present. So I told Nazi we would take that up because I called out whether the owner of the property was there, and there was no one present at that time. But because we had an audience of respondents, we were taking, and we still had other attorneys, I believe. So I didn't confirm or make oral pronouncement.
All right, well, what we can do is, we'll go back and take a look at the record, because at least, again, with the tenant was here, and then with the evidence that was presented, again, it was not controverted, but again, let's finish the docket, and then we'll go back and take a look. All right,
Yeah,
we'll finish the docket. Let's do 7.1, then we'll go back and confirm.
Chief Co-Compliance Officer Jocelyn Ramirez for the Town of Pembroke Park, case 8397. Property owner, Timely Property, Inc., site address 3001, West Hallandale Beach Boulevard, Pembroke Park, Florida, unit number 312. A notice of violation was sent by regular mail, 11/2023. A notice of formal hearing with a copy of the notice of violation and an affidavit of noncompliance were sent by certified mail, July 19, 2024, posted to the property August 7, 2024, and Town Hall, August 9, 2024. Violation is for Marcelo Malensnitsi, operating without a business tax receipt. As of July 18, 2024, the property is not in compliance. I have had no communication with the property owner regarding this. So it is the town's motion to have this corrected within 30 days. If not, a per diem of $250 and $100 admin fee.
Anyone here on case number 8397, Timely Property, Inc., seeing or hearing no one come forward? Based on the testimony evidence presented, there is substantial and competent evidence to support the violations existing on the subject property. The respondent is hereby ordered to come into compliance within 30 days or face a $250 daily fine, which will continue to accrue until the property is in compliance. The respondent is also assessed $100 administrative costs. Next case.
Next case on section 7.4 on the agenda, case 8409. Chief Co-Compliance Officer Jocelyn Ramirez for the Town of Pembroke Park, case 8409. Property owner, Timely Property, Inc. Site address 3001 West Hallandale Beach Boulevard, unit number 101. A notice of violation was sent by regular mail, April 17, 2023. A notice of formal hearing with a copy of the notice of violation and affidavit of noncompliance were sent by certified mail, July 19, 2024, posted to the property August 7, 2024, and Town Hall, August 9, 2024. Violation is for installation of electrical locking system without a permit. This is a repeat offense, referencing case 5925, which has been entered into the record. The tenant did call me and did request time to correct this. So there's the town's motion to give 60 days, if not a per diem of $250 and $100 admin fee.
Case number 8409, Timely Property, Inc. Is anyone here on that case? Hearing or seeing no one come forward, based on the testimony evidence presented, I find there is substantial and competent evidence to support the violation issued against this property. Respondent is ordered to come into compliance within 60 days or face a $250 per diem daily fine until such time as the property is in compliance. The respondent is also assessed $100 administrative costs for today's hearing. Next case.
Next case on section 7.70 on the agenda, case 8689. Chief Co-Compliance Officer Jocelyn Ramirez for the Town of Pembroke Park, case 8689. Property owner Pembroke Park Lakes, Inc. Site address 43-A West Lake Drive, Pembroke Park, Florida. A notice of violation was sent by regular mail, June 28, 2023. A notice of formal hearing with a copy of the notice of violation and an affidavit of noncompliance were sent by certified mail, July 19, 2024, posted to the property August 7, 2024, and Town Hall, August 9, 2024. The violations are for item number 1, installation of metal shed without a permit. Item number 2, plastic closet pantry is stored outside. And an AC mini split. As of July 18, 2024, only 2 violations remain, which is the metal shed and the plastic closet pantry outside. So it is the town's motion to give 60 days to correct those. If not, a per diem of $250 and an admin fee of $100.
Case number 8689, Pembroke Park Lakes, Inc. Seeing or hearing no one come forward. Based on the testimony and evidence presented, I find there is substantial and competent evidence to support the violation issued against the subject property. The respondent is ordered to come into compliance within 60 days or face a per diem fine of $250 per day. The respondent is also assessed $100 administrative fee. It is noted that the daily fine will continue to accrue until such time as the property is in compliance. Next case.
Next case on section 8.4 on the agenda, case 6185. Chief Code Compliance Officer Jocelyn Ramirez for the Town of Pembroke Park, case 6185, property owner Nation Dom Inc., site address 5100 Southwest 41st Street, Pembroke Park, Florida. A notice of hearing to confirm fine was sent by certified mail July 19, 2024, posted to the property August 7, 2024, posted to Town Hall August 9, 2024. It is the town's motion to confirm the fine of $107,800, and the property is still not in compliance as of July 19, 2024.
Case number 6185, Nation Dom Inc. Seeing or hearing no one come forward, based on the testimony and evidence presented, there is substantial and competent evidence to support the town's position to confirm the fines. The property to date remains out of compliance. The fines are hereby imposed. The respondent is ordered to correct and comply by bringing the property into compliance. Failure to correct the violations and come into compliance will result in the continual accrual of the per diem fine. The respondent is also assessed $100 administrative cost for today's hearing. Next case.
Sorry, what is that case number?
The case number is 6185.
Thank you.
You're welcome.
Next case on section 8.5 of the agenda, case 7003. Chief Code Compliance Officer Jocelyn Ramirez for the Town of Pembroke Park, case 7003, property owner Plinio Kahina, site address 2318 Charles Road, Pembroke Park, Florida. A notice of hearing to confirm fine was sent by certified mail July 23rd, 2024, posted to Town Hall August 9, 2024. It is the town's motion to confirm the fine of $24,700. The property is still not in compliance as of July 23rd, 2024.
Madam Magistrate, if I just may make a brief record. It looks
Yes.
like someone did sign in actually on this case. There's no one here. I don't believe the person that did sign in under the name of the owner, Plino Canina, talked to any members of staff, and I guess was here and decided to leave, and we could proceed forward.
And for the record, just an audible yes or no. Did staff speak to anyone on this case prior to the person shown on the sign-in sheet? Did anybody identify themselves associated with this case leaving?
No, I didn't speak to anybody.
Okay. And let the record reflect, anyone here on case number 7003, Plinio Kahina, seeing or hearing no one come forward, based on the testimony and evidence presented, there is substantial and competent evidence we're imposing the fine. To confirm the fine, the evidence reflects that the property still remains out of compliance. The fines are hereby imposed. The respondent is ordered to comply and correct the violation. Failure to correct the violation and come into compliance will result in the continued daily accrual of the per diem fine. The respondent is also assessed $100 administrative cost for today's hearing. Next case.
Next case on section 10.1 of the agenda, case 6658. Chief Code Compliance Officer Jocelyn Ramirez for the Town of Pembroke Park, case 6658. Property owner Lidiana Blonsky, site address 3140 West Hallandale Beach Boulevard, unit number 438, Pembroke Park, Florida. A notice of hearing to extend time was requested by the owner and was sent by certified mail July 19, 2024, posted to the property August 7, 2024, posted to Town Hall August 9, 2024. The property is not in compliance as of July 19, 2024. Therefore, it is town's motion to give the property owner 90 days to correct the violations, if not, per diem of $100 and a $100 admin fee.
Case number 6658, Liana Plolinski. Seeing or hearing no one come forward, based on the testimony and evidence presented, there is substantial and competent evidence to approve the request for extension of time. Officer Ramirez, this is the respondent's request to the town. Is that correct?
Yes.
Okay. Respondent is hereby ordered to come into compliance within 90 days or face a per diem daily fine of $100. The respondent is also assessed $100 administrative cost for today's hearing. Failure to come into compliance and correct the violation will result in the continued daily accrual of the daily fine. Next case.
I'm going to bring back up the record on that piece so we can include the docket.
Okay. This is 3192-4 West Hallandale LLC, Management Office. The owner of the property was cited. The attorney, Attorney Dawson, represents the tenant. The tenant nor the attorney are here on behalf of the owner of the property. Or with authorization to speak on behalf of the owner of the property as it pertains to this case being on for confirmation of the fine. Does Officer Ramirez or Assistant Town Attorney like to add anything to the record? No. Okay. Seeing that there is no attorney here for this case and the respondent, which is the owner of the property, is not here on this case, we will we'll move on to the next case that has an attorney present. Thank you. So I wanted on recall, just so, and I'll put this on the record. That case was the second case with an attorney, but not the attorney of record. We had a room full of respondents, and so rather than take a case that didn't have someone presenting, I, in essence, put it on recall to be called after because Attorney Dawson was not representing the interest of the property owner. So, but we can hear it now.
Yes. So I'll read it into the record. Chief Code Compliance Officer Jocelyn Ramirez for the Town of Pembroke Park, case 9150, which is on section 8.6 of the agenda. Property owner 3192-4 West Hallandale LLC, care of Management Office. Site address 3192 through 3194 West Hallandale Beach Boulevard, Unit J, Pembroke Park, Florida. A notice of hearing to confirm fine was sent by certified mail July 19, 2024, posted to the property August 7, 2024, posted to Town Hall August 9, 2024. It is the town's motion to confirm the fine of $16,100. The property is still not in compliance as of July 19, 2024.
Sorry, could you confirm the amount?
$16,100.
16,000.
Okay, this is recall for case number 9150.
Oh,
Oh, 915, okay, I have it here.
Yes, I know.
the wrong one. 9150.
Thank you. 3194-4 West Hallandale LLC, seeing or hearing no one come forward. Based on the testimony and evidence presented, there is substantial and competent evidence to support the town's position to confirm the fines. The property to date remains out of compliance. The fines are hereby imposed. The respondent is ordered to come into compliance and correct the violation. Failure to correct the violation and come into compliance will result in the daily continual accrual of the per diem fine. Respondent is also assessed $100 administrative costs for today's hearing. I believe that's the last case.
Yes, that concludes all the cases on the agenda.
Adjourned. 1:15.
What's the time?
1:15.